I'm going to do that again. I am your father. Welcome, everyone. The Sunshine Ordinance Task Force meeting, Wednesday, June 5th, called to order at approximately 4:19 p.m. Let's just do a quick check of who's here before we do a roll call. 12055, that's city attorney, and do I have the complainant? I just have the respondent. Okay. What? Oh, I just have the respondent. I can't see. And 12056, do I have the complainant and the respondent? Excellent. Thank you. And 12059. Supreet Pabla. Okay, so do I have the respondent? I know, I'm just being official. Okay, and 13005, complainant and respondent. Complainant, gosh, she must have just stepped out. Okay, Madam Clerk, can I get the roll call?
Item number 1, roll call. Do you want me to take roll call now? Would you like me to take roll call?
What?
You like me to take roll call?
Please take the roll call.
All right. Member Nee?
Here.
Nee present. Member Washburn?
Here.
Washburn present. Member Pilpel?
Present.
Pilpel present. Member Sims? Sims present. Member David?
Present.
David present. Member Highland?
Present.
Highland present. Member Oka?
Present.
Oka present. Chair Fisher?
Present.
Present. And then Member Grant is absent. You have a quorum?
Madam Chair, move to excuse Chair Grant.
I think we decided that we don't need to excuse people because it doesn't matter anymore. We looked at the rules.
Well, okay.
Yeah, that's why. It has no bearing.
I think it should somewhere be noted that Member Grant's absence is due to work-related, reasons.
Can we make a note of that, Madam Clerk? She's out of town. Way out of town. Madam Clerk, do we have any agenda changes?
Yes, the agenda changes were given to you.
Do we have to tell everybody?
Yes, you do.
Okay. Oh, you want me to say them? Okay. Let's...
I can go.
Yeah, why don't you do it?
No problem. So for item number 2, I received a notice that both parties will agree to a continuance till August.
Okay.
For item number...
Can I hold you up there? So
Sure.
Should we vote on these one by one, or we wait till we get to the items?
You can, or you can vote them as a whole. It's till August.
Here are the announcements, sorry.
Okay. So file number 13005 and 13011, the Sunshine Office received a request for continuance from the complainant. And those are the only agenda changes that I have.
I changed my mind. Let's vote on those separately. Can you make a motion on this one? 12055.
So with regard to item 2, file 12055, I actually would like to discuss jurisdiction tonight if the parties are here, and if we find... What?
Only one is here. Only the
Who's-
respondent is here.
Oh. Sucks. All right.
But they both
Well,
agreed.
I'm willing to continue it. I just wanted to say I am not entirely convinced about jurisdiction. And did we get a memo? I only got copies of 2 of the city attorney memos.
Through the chair to Member Pilpel, I did not prepare a memo for this item because it was stipulated that both parties would like a continuance.
Okay. So that's fine. I guess we'll see it in the fullness of time. I just wanted to say I'm not convinced about jurisdiction because it was in the context of a court case. That's all.
I would note that neither party contests jurisdiction, but it still is an issue.
Okay. That's fine.
We're just going to kick this one
So
down
still you want
to
a
next
motion?
month.
So
Yeah.
I will so move to continue the matter to the August meeting, not July. Is that what they're... is it
Yeah, they
routine?
want it August.
Okay.
Second.
Do I have to take public comment on this? Public comment?
12056.
Really? Seeing none, public comment is now closed. And the other, hey, Chris. Can we take that without objection? Yep. Okay. Can I, Madam Clerk, can I bundle items 6 and 7 since the complainant has requested a continuance? Could I bundle them together, or do I have to do those separately?
Madam Chair?
Yes, Member Nee.
Just a little behind the podium housekeeping matter here. On the memoranda from DCA 3, they've been misdistributed. This is my fault, really. But look at what's in your packets, and I think you'll find that what you have are multiple copies of the same thing. So what we need to do is just redistribute what we have so to make sure that each of us gets a copy of each of the memos from DCA 3. And I apologize for the inconvenience.
There are 3 memos?
I've got 3.
4, okay.
Well, I have one.
Get the
Here,
13011.
see if you've got those, because I've got them on my...
I just have one of them.
Well, that's it. We have multiple copies of one memo, so what we need to do is redistribute.
Got them online. I don't need them.
The only one I don't have is 13011.
Okay. Let's see now.
Did that come around,
There.
or is that?
What's the name of that?
Holiday Test versus Arts Commission, OR 13011.
Here it is.
Are these all
I'm
of
about
them?
to get it.
Are these all of them? Or these are all the same one?
Yeah. All right.
How much for paperless?
You the holiday test one? Here's
I got it.
anyone else?
Copies of one.
Anyone else need that?
There's 405, but there's a 1.
Just have 2 of them now.
I have 13.
Probably each of us has just 2 right now, so we need...
I have all.
I don't need any.
Do you need either?
I don't need any. I received
Need
one.
12, I need 12059.
Here you go. Pass that to him. Okay.
Okay, so as to 6 and 7, I think we got the memos. I hope there are copies out there for the public. For 6 and 7, should we hear from the complainant for the basis for the continuance request and from the respondent and discuss 6? It sounds like that was not agreed to by the respondent.
Madam Chair, or Madam Clerk, we'll just wait till we get to that item then, or?
No, we can hear it right now.
Okay. So then we'll hear from the complainant first.
Oh,
Do
excuse
you have,
me.
hold on.
Jurisdiction? Which one are we hearing right now?
One,
This is on the request to continue items 6 and 7.
Got it, thank you.
yes, 13005 and 13011. How much time?
Ma-
Yeah, go ahead.
I think that the appropriate thing is to make a motion and then to take public comment on the motion and then to vote after the motion. So what I would recommend is that, right,
Yeah, let's hear both sides first.
okay.
Madam Clerk, how many minutes does she have on this? Yes. Why would you like a continuance?
Hi, members of the task force. I know this has been going on for quite some time, and I've come here when I've been asked or come at other times, but I'm diabetic, and once every 30 days I go on dialysis, and today I had to leave early. I couldn't finish it, so I request that this be put over for a month.
Okay. Do we hear from the respondent now, Madam Clerk? Yes. Would the respondent like to agree to this or say a few words?
Hi, Kate Patterson, San Francisco Arts Commission. We'd like to see this, we'd like to move forward and have this heard tonight, just so we can wrap it up and not have to come back again. So it would be our preference to go ahead and move forward to hear it. Thanks.
Motion?
I would like to make a motion to continue this to the next regularly scheduled meeting.
These are both items 6 and 7? Okay. Second.
Okay, the motion has been seconded.
What are we doing?
Oh, this is for, sorry, Member Oka, this is a continuance for items 6 and 7. The motion has been made to continue them to next meeting, Madam Clerk? Yes, next meeting. So we have discussion?
We seconded, I think.
I believe I second, Member Oka.
Yes.
Public comment?
Okay, is there any public comment? Seeing none, let's take a vote. Seeing none, I'm closing public comment.
Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
Aye.
Pilpel, aye. Member Sims?
Aye.
Sims, aye. Member David?
Aye.
David, aye. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Member and Chair Fisher?
Aye.
We have 8 ayes.
Okay, so the motion passes. Madam Clerk, do I have to take, no, item 1 is closed now?
Item 2.
I don't have to take public comment on what we just closed? Okay.
No, it's already done.
Can you read item 2, please?
Item number 2, file number 12056, complaint filed by Alan Grossman against John St. Croix, Executive Director, Ethics Commission, for allegedly failing to justify withholding unidentified public records as exempt under provisions of the Sunshine Ordinance.
Minor correction. This is item 3.
I'm sorry.
Can you read item 3, please?
Yes, item number 3. 2 was...
Yeah, 2 is gone. Okay. Do we have a motion to accept jurisdiction on this?
So move.
Second.
Okay, so the complainant goes first, right?
Excuse me.
Public comment?
Public comment?
We haven't had any yet. Do we have any public comment
On jurisdiction.
on jurisdiction for item number 3?
Yes. This is your complaint,
Is yours?
Mr. Grossman. This is your complaint, file number 12056. This is your complaint, sir.
Seeing none, public comment is closed.
Can we take this without objection?
Yeah, do we need a vote for this? Okay, we'll take this without objection. Mr. Grossman, come on up.
I have 5 minutes, is that it?
Yes, you have 5 minutes.
Okay. You've been bombarded with a lot of legal stuff, and I'll try to simplify it a little bit, but I think the first thing we have to mention is my memo in which I raised the issue of the 6-vote rule. With only 8 of you here, I have to, if the motion were whether there was a violation, I'd have to get 6 of the 8 or 75% of the votes in order for the complaint to be sustained, which is actually backwards, as I tried to point out in my memorandum, because the presumption is every public record is fully disclosable, and the burden is on the respondent or custodian to establish or justify that one or more of the requested records is exempt. So any motion that you make should follow the burden of proof, which is that the respondent establish that the exemption applies. Otherwise, let's face it, the complainant is really in a pickle. Okay, so I made that point, and when the motion time comes, I assume I'll have a chance to speak about it again. There are a couple of things about the response to my records request, which was primarily directed to what records were produced by the Ethics Commission and its staff in connection with the draft regulations for the Ethics Commission's handling of sunshine referrals, or referrals from the task force. And I included, obviously, emails and other forms of communications between the staff, commissioners, and the city attorney. I got back a bunch of copies of documents or records that I was familiar with because they'd either been submitted by the task force and I had worked on those, or they were fairly innocuous. Who should I send things to? But in but what I didn't get, of course, were the records that Mr. St. Croix Crane were exempt. He also, at the end of the emails between myself and the technical person over at Ethics, he said that the Commission is not required to create documents that don't exist. I never asked them to create any records. I only asked for what they had. So that explanation I find a bit odd, unless he was talking about records that would have fallen within the Sunshine Ordinance provisions of 6724B. If they didn't have any, then he could say, we don't have any under those exceptions. But the real point I think he's made is that he's got three exemptions that he could apply. The attorney-client privilege and the two work product principles or exemptions. So the first, of course, is the absolute exemption, which relates to the attorney's thoughts and so forth. And then there's what is called a qualified exemption within the work product. It's defined that way, in fact, in the law, I'm pretty sure. So he's got an unknown number of records which he claims are subject to one or more of several exemptions. And he says, and I don't even have to tell you what they are, which exemption or exemption applies to each. And as I tried to make clear, the issue of justification for the exemption and the details of how the system is supposed to work breaks down totally. If you have an unlimited number of exemptions you could claim exist against an unlimited number of records.
Okay, thank you.
Is that 5 minutes?
Yeah, I mean, you
Can I just,
finish your
I
thought.
didn't hear anything.
Finish your thought. It's
Okay, I just want to
We'll
point
give
out.
the same thing to the respondent.
Okay, I just want to point out that in two respects, the memo that Mr. Threet sent around, and which I got this morning, is inaccurate in a couple of respects, and I'd like to correct that when I have a chance. Thank you.
Okay. Thank you. Do we have any members of the public who want to introduce facts and evidence to support the complainant? Okay, seeing none. Mr. St. Croix?
Good evening, John St. Croix representing the Ethics Commission. I'll keep it simple. Mr. Grossman requested a number of documents. Staff identified all of the responsive documents, determined that some needed redaction and others were not disclosable. The rest were provided to Mr. Grossman on a timely basis. The specific areas of law that justified the non-disclosure of the documents that weren't turned over were stated as required, and his subsequent correspondence was not a document request and therefore did not require a response. And he's right, we don't have and I will emphasize that we do state that if he wants us to create a log of documents, that there's no requirement that we do that. So from our perspective, no violation has occurred. Just for the record, I haven't seen Mr. Threet's memo.
Yeah, there's copies on the table. Do I have any members of the public to introduce facts and evidence in support of the respondent? Okay, seeing none, I'm going to open this up to the task force members who would like to ask any questions of the complainant and the respondent. What? Oh, hi. Yes, Member Washburn. Sorry, I didn't look this way.
I have a question for Mr. Grossman. You ended your remarks saying that there were some inaccuracies in Mr. Threet's, DCA Threet's memo. If you could explain what those are, I would appreciate it.
I was confused, actually. I thought I was entitled to a rebuttal after...
Yes, we do the questioning now, and then when the interminable questions have ended, you get 3 more minutes to rebut. So this is kind of your free time, so go for it.
Okay.
Right, Madam Clerk, it's not timed on this, right?
They're not appreciated.
Yeah.
Let me just find the place on my... I have so many memos.
We feel your pain.
From
With
60
respect
years
to
of
memos.
law practice. Well, okay, I found it. I think the biggest problem is that he relied on this Axel Rad case and quoted, in a sense, from it. But actually, he left out something, which is, in the nature, what is the privilege of the work product principle. And the court said the attorney work product rule, they don't even call it an exemption, codified in Code of Civil Procedure under Section 2018, creates for the attorney a qualified privilege against discovery of general work product. You would never get that out of what is in this memorandum. And if you read the whole paragraph, you'll see the importance of the distinction. Anyway, I have a long history with the city attorney over this question of the dual function of the work product rule, but I won't bore you with it now. The other thing that I thought was somewhat dubious was the long quote from the Haney case, which has been a pillar of the city attorney's support for this notion about privilege logs. But the Sunshine Ordinance provision that I relied on 6721B is not the one to which the Good Government Guide talks about when it talks about privilege logs. So ideally, the presentation would have compared those two for you to decide instead of having me point it out. That was the parts that I thought were somewhat disingenuous.
Let me finish one at a time. Member Washburn, do you have anything to add to that? I'll go in order.
No, I'm still, I have to say, I read the memo. I did have time to read it today. As a non-attorney, I had a lot of questions, of course, while I was reading it, but I just wanted to, my understanding is that there were 3 bases cited for withholding the information, 2 related to work privilege, or work product, and 1 related to attorney-client privilege. What really caught my eye, though, was some brief mention of, it's on the page 4 of the memo, right under the heading information. It's an exception to the attorney-client privilege. It says, an exception to this rule applies when the attorney-client communication comes within the ambit of Section 67.21I or 67.24B1 of the Ordinance. And I'm not quite sure what that means.
Well, what it means is what I just alluded to in my original presentation, which is Mr. St. Croix said they don't have to create documents in order to satisfy my request. Mm-hmm. And he didn't say we have other documents that are exempt. He said you're looking for documents that are records that don't exist. Well, the only place where the attorney-client privilege would change the exemption, the only place in the ordinance where that exemption does not apply is in the case of these communications between the city department or agency and the city attorney's office, which are attorney-client privileged in general, if those relate to any of the open government laws, which included, the Sunshine Ordinance and any regulations enforcing those laws. So I just didn't pay much attention to that because I assume that's what Mr. St. Croix had in mind. If he does have those, then they must be disclosed. I mean, if there's an email transmitting a draft of the regulations from Mr. St. Croix to anybody in the government group, that would have to be disclosed.
Member Pilpil? Oh, wait, Member Washburn.
So I guess what I'm trying to figure out is you requested, any or all documents related to what transpired before that meeting where those regulations were brought before the Ethics Commission, and this was a whole project that we were involved in. So, and what you got back was some documents that were readily available, which you probably had copies of, and then you were told there are other things that exist that you were withholding because we're invoking these exemptions, but there was no specificity. So, am I right? There was no specificity about the types of things that were being withheld.
Right. Well, the curious thing is that the attorney-client privilege would work if I was looking for records that did not involve the Sunshine Ordinance and the Task Force and the Ethics Commission's own rules. But if they didn't, or rather the other way, if they did involve any of that, then the attorney-client privilege does not apply. It's right in the ordinance, and Mr. Threet's memo notes that because that's what he said. So either they don't exist or there's a problem. Let's put it that way. And I can't answer that.
So I guess what I'm trying to understand is if in cases where a city body is withholding documents because of these exemptions, I thought that the documents had to be enumerated in a general way so that you knew what it was exactly that was being withheld and for what reason. So I'm wondering, was that done? Were you given some list of, we have this, this, and this, but you can't have these things because of these exemptions?
Well,
If that didn't happen, then I'm thinking there was a black hole that you can't see.
Well, the issue for me is, I don't know how many there are. There could be 3 or there could be 30. Okay? We got 3 different exemptions that could apply. We know that the attorney-client privilege and work product can't be applied to the same record because once it leaves the lawyer's office, it's no longer work product. It becomes part of the attorney-client communication. So you have those. And then you have, and which is actually a pretty important issue, is since the qualified work product rule is tested by a standard in the context of litigation, whether it will affect the discovery. I forgot the exact words. It doesn't have any inherent connection to a records request for a record that would be subject to the qualified work product rule because there's no other litigant involved, and the whole purpose of it is to protect the party whose lawyer is doing this work if it would hurt them to reveal it. On the other hand, we're talking about a record that is presumptively disclosable. So the policy has already been established. It can't hurt anybody if it's disclosable. That's the whole point of it. So this is a bit of a conundrum because you end up chasing your tail, essentially, and you can't do that. And I don't care what the Haney case says because it doesn't even relate to this. It doesn't relate to us, and I brought along with me the Open Government, which was issued by the Reporters Committee of the Freedom of the Press. And this is what they say. It is important to note that each piece of information requested that is enumerated in Section 6254F, which is in the CPRA, must be considered and analyzed separately by the agency. A law enforcement agency, like any other agency, subject to the provisions of the CPRA, bears the burden of justifying its refusal to disclose otherwise public records with regard to each separate piece of information requested. That's on page 14 of this book. So this, I don't want to sound like a broken record, but it just makes there's no common sense to it. If it is exempt, fine. Find that it's exempt. But you have to know what you're exempting. How else can you do it?
Mr. Grossman, quick question. So, we do. May I?
Are you guys okay
May I
with
jump in?
asking a quickie? Go ahead.
All right.
I've got to go with my stack.
So it's really a context issue. You're saying that with these 2 exemptions, there's no litigant, so it doesn't apply, and then there's no attorney-client, and therefore doesn't apply. That's your point.
I have a hearing problem. It's not very good, and it doesn't. The hearing aids don't help all that much. So if you wouldn't mind talking,
I'll repeat that again. So it seems like there's a context issue here for claiming those 2 exemptions. In the first place, you mentioned the work product. There's no litigant, therefore this does not apply. In the second case, I would say, where's the attorney-client relationship regarding those documents, and therefore that doesn't apply. That's your gist here. So those two exemptions they're trying to apply are not relevant in the context of this information in this body.
Well, the work product is, in a sense, the product of a lawyer. And so the issue might be, and I'm being, speculating, they have 3 in-house lawyers, I think, at the Ethics Commission. And instead of going to the city attorney, they could have gone to one of those, and he or she furiously wrote up a lot of stuff on these regulations, and those might be, subject to work product, even though they're not in the city attorney's office, but they're sitting in the Ethics Commission's office. But then they become subject to the exception to the rules, which is if it concerns open government, the Ordinance, the Public Records Act, the Brown Act, any of those, it's not exempt.
So that trumps it, is what you're saying, essentially.
Yeah.
Thank you.
Okay, thank you. I believe Member Pilpel, you've been waiting patiently.
Thank you. Thank you very much. Okay, so Mr. Grossman, let me start with you. The October 3rd request that you made was responded to on October 12th. So, and it was not an immediate disclosure request, so you're not contesting that there was a timely response, correct?
No,
okay.
I'm not.
So within the response on October 12th, as Mr. St. Croix indicated in his letter, page 1, page 266 of the packet, there were 127 documents provided, 6 had been partially redacted, and there were additional documents that were withheld in their entirety, and that's what's in contest. So the 121 documents that were provided without redaction, there's no issue about them, correct?
I think it may have been 121 pages. I'm not sure it was separate documents. But
okay.
In any case,
that's not a problem.
Not a problem.
The 6 that had been partially redacted, is there an issue? No, you're good with the redaction and the justification, all of that?
Let me put it this way. I think one could argue whether the email address of a commissioner should be redacted or not. But it's not worth complicating this.
We're not arguing that point tonight.
Not arguing that.
Fair enough. Okay. So then we're just on to the third category of the documents that were not disclosed in their entirety and the justification for that withholding. Am I correct?
They were not disclosed at all.
Right. And the justification, in your opinion, was not sufficient as to the withholding of those documents in their entirety?
It's not my opinion. It's what the law is.
Okay. So that's the issue that's in contest?
Yes,
okay.
sir.
And you don't know how many documents there were, nor any more about the justification besides the quoted language?
The 3 of them. He could have added another one, official information. He could have added, any number.
You've answered my question. So now let me go to Mr. St. Croix and see if I can get somewhere with that point. Thank you.
Okay, thank you.
Did you have questions for?
Yeah.
Okay. Mm-hmm.
Okay. Hello. So with regard to that third set of documents that were not disclosed, that presumably were responsive documents that were withheld in their entirety, can you give us a sense of how many documents there were and something about them without revealing their contents?
No. I don't know how many there were.
Okay.
They fell under those 3 categories. And I think the essence of this is that Mr. Grossman seems to think that no documents in this particular case can exist under those exemptions. And, we found that there actually are documents that do.
Okay. So if it's in some ways a dispute between the various privileges, the attorney-client or the attorney-work product privilege versus 67.27I about disclosing all information related to the Sunshine Ordinance and San Francisco government ethics laws, and that the ordinance intends to trump state law in that regard and to the extent that there's a conflict, and you're saying that if there was a conflict, that you resolved it some other way. Can you help us understand how that can happen? Because that's where I see a bit of the conflict.
Can you restate that? I'm sorry.
I can try. So 67.27I provides that any communication with the city attorney related to the Sunshine Ordinance or the Public Records Act or government ethics laws are subject to disclosure, notwithstanding state law elsewhere?
Understood.
Okay. So you're saying essentially that notwithstanding that provision, that you still felt that under the applicable section of the Evidence Code and as incorporated into 6254K and the reference to CCP 2018.030, that they were still not subject to disclosure, whatever these documents are.
Right. There are some responsive documents not subject to disclosure under those categories, correct?
So in order for us to do more than just trust you, can you tell us something about the nature of that communication that would not fall under 67.27I?
No, not at the moment anyway.
If you look at section 6727D, it reads, when a record being requested contains information, most of which is exempt from disclosure under the California Public Records Act and this article, the custodian shall inform the requester of the nature and extent of the non-exempt information, inform of the nature and extent of the non-exempt information, and suggest alternative sources for the information requested if available. That, to me, reads like you are required to.
No, what that section is saying is if there's disclosable information in the non-disclosable documents that's available elsewhere, that we have an obligation to inform the petitioner of where those documents are available. That's what that says.
Okay, so if I could just conclude, if you don't have that information now, would continuing this matter or doing something else allow a better answer? Because I'm personally kind of stuck between finding a violation because we have no further information or not finding a violation because we don't have further information. I would like to understand generally the nature of the documents that weren't disclosed and the basis for the non-disclosure.
Well, that's why the Haney decision is appropriate here, because if you ask me that information as a courtesy, I could provide it, but that's creating a new document, and I don't have to do that.
I'm not asking you to create a document. I'm asking you to express to the task force something about the documents that you're declining to disclose, and I can imagine that there are other ways to get at this information.
I can do that, but I wasn't prepared to have that question asked of me tonight, which is not why I'm not prepared to answer it.
Okay.
And to go back to 6727D, it says, I'll read it again, when a record being requested contains information, most of which is exempt from disclosure, the custodian shall inform the requester of the nature and extent of the non-exempt information. One. That's one part of it. And suggest alternative sources if available. That's how I read that. Did you provide any information on the nature and extent of the non-exempt information?
The non-exempt information is not available in another source.
That's not how this reads.
Yes, it does.
That's not how I read it.
I understand. And I actually sympathize to your reading because I initially read it that way too. I had to reread it several times and talk to more than one of my attorneys to comprehend what it's actually saying.
727D. Yeah.
Okay, so maybe as we continue to go through discussion, if you want to think about whether a continuance would allow you to gather more information to be responsive, I don't want to make the wrong decision here, and I'd like to have some generalized understanding of the withheld documents. Is it 3 documents that's 5 pages and it was, an email that was da-da-da-da, or is this 30 pages of something? And something about the basis other than the generalized, it may fall under one of the privileges. I understand that it may fall under one of those privileges. I get that. I need to have something more to better understand it. That's where I am.
Madam Chair.
Oh, yes, Member Neal.
Member David is waiting patiently.
Well, Member David's been waiting.
I'm fine.
Okay.
Go.
Is this Oh, you're thinking, go ahead, Member Neal.
Mr. St. Croix, please. The withheld documents, you don't know how many there are.
No, sir.
So you have not seen them, the withheld documents?
No.
This creates an additional difficulty because I think one of the questions we have here is whether those withheld documents contain both exempt and disclosable information. And where that is the case, there is an obligation on the part of the respondent to provide the disclosable parts. So I would tend to agree with Member Pilpel that we need more information to go on here.
According to my staff, in the non-disclosed documents, there's no portion of any of them that has non-exempt information.
That may be.
Hold on a sec, Member Washburn. Member David, you've been so patient. Then you.
I feel,
I'm going in stack here. It's going to be Member David, then Member Washburn, and then Member Sims.
I feel like this is like the ultimate conundrum that on the one hand, we're saying that everyone agrees that if the documents talk at all about open government, they're disclosable. And that's what Mr. Grossman asked for. And then the response is that there's a certain number of these documents that talk about open government that are not disclosable. And I don't know where to go with that, right? I mean, if he's asked for documents about open government and no one's disagreeing that documents that have to do with open government are disclosable, then how do we have a set of documents that are the documents that you are saying fall under the whatever privilege you want to call it, don't have to do with open government? Like I'm really confused about how to deal with that.
I don't have the entire ordinance in front of me, but I think that the exemption is that attorney advice about open government is exempt from non-disclosure. That doesn't mean every single document that ever was created that mentions open government is automatically disclosable. And again, I don't have the statute in front of me, but I don't think it's just every single thing that has any tangential relation to open government is automatically disclosable. Obviously, a great deal of it is, but I don't think that that's an infinite.
Just one follow-up. So then the next question where, okay, I can understand you're saying that you don't need to, that there's nothing that says that you have to create a new document, right? But is there, it seems to me that it's reasonable to provide Mr. Grossman with the number of basic information, right? Hey, Mr. Grossman, there are 7 documents, a total of 70 pages that we're not disclosing because of this, this, and this. Are you saying that you're saying that, I just wanted to, in your opinion, that's not something that the ordinance calls on for you to do?
I don't think it's absolutely required. I do understand that you think that that's probably something we should do, of course. And perhaps that's the case. I will be honest that we have had such a very difficult and animous relationship with Mr. Grossman over time that, providing him with the law requires and not going a step farther to me is just a symptom of that relationship. And it's unfortunate, but it's not a one-way street. He's been rather harsh in his descriptions of me personally a number of times, and And I've heard some things on tape that I didn't attend. So we try to maintain civil and cordial relations, but taking that extra step in a case like this, I'll be honest, didn't do it.
Can I ask Mr. Grossman a question, or is that?
Hold
No, go
on.
ahead.
Did you want to ask Mr. St. Croix something, or?
No, I actually
On the
wanted
same-
to ask DCA 3.
Go ahead.
Go with that first.
I'm trying to understand the law here, and I'm confused about what the restrictions or what the possible exemptions are for documents having to do with open government. I mean, here I feel like we are falling down a rabbit hole here. This is about a matter that involves this body and the Ethics Commission and the service of open government. And, here we are trying to understand how the regulations, how all of that came about. And we can't get an accounting of even what documents there might be. And so I'm as frustrated as everybody else here. But the thing I want to know is what are the possible exemptions for documents having to do with open government and sunshine? When would those not be disclosable?
Through the chair to Member Washburn, I'm going to reframe your question because I think it would be useful. So, as a general matter under state law, there's an exemption for disclosure for documents that constitute attorney-client privileged communication or attorney work product. There's an exception to that exemption in the Sunshine Ordinance, and it occurs in two different places. One is 67.21I. The last sentence of that provision says, all communications with the city attorney's office with regard to this ordinance, including petitions, requests for opinion, and opinions shall be public records. And there's also an exception, 24B1. There's several subsections of that exception. It says, notwithstanding any exemptions otherwise provided, and the following are public records subject to disclosure under this ordinance. I'll just note the ones that I think may have relevance here, but there are three subsections. A record, subsection II, a record previously received or created by a department in the ordinary course of business that was not attorney-client privileged when it was previously received or created. In subsection III, advice on compliance with, analysis of, an opinion concerning liability under, or any communication otherwise concerning the Public Records Act, the Brown Act, the Political Reform Act, and any San Francisco government ethics codes or this ordinance. So those are the two areas. If there is attorney-client privileged information or attorney work product, that comes within the purview of this. Like the broadest section of this says concerning these statutes is a rather broad language. So that's where they come from.
Actually, you were next, and then, is this the same?
I just
Yeah,
wanted a
topic.
clarification. So the broadest reading of that would be communication otherwise concerning the CPRA and our ordinance. So
Yes.
you could argue that the documents Mr. Grossman requested had to do with communications regarding this ordinance. This was about regulations that the Ethics Commission was developing to govern how they were going to deal with our matters. So the whole issue was about enforcement of this ordinance So I would say communication concerning this ordinance was what those documents were about.
Are you asking
I'm
a
just,
question from me?
I'm just asking your opinion of my interpretation.
On its face, it seems that that is a reasonable interpretation. I don't quite understand the nature of these documents from the descriptions that have been provided, so I'm hesitant to say that that's the case because I don't fully understand the nature of these documents.
So that's part of the problem. That's the conundrum. We don't know, we don't have an accounting of what these documents are, because Mr. St. Croix says that would be, to provide that accounting would be creating a new document, which he doesn't want to do even as a courtesy because of the animus between him and Mr. Grossman.
And Member Washburn, you're focusing on one aspect of the problem presented by this complaint, which is the exemption itself. But there's another aspect to it, which is what forum the issues are being raised in and what is the procedure to resolve this conflict. If there is a lawsuit was filed in the court system seeking these documents, there would be available through the court an in-camera hearing where the parties, the city could present the documents and just, so that the judge could examine and could make their arguments as to why they were exempt and they didn't come within this exception in the ordinance. And then the attorney for the member of the public seeking the documents could have an in-camera, possibly have an in-camera examination also. And then the judge would make a decision. But that kind of procedure is not available at this level.
Thank you.
If you were next. Member Pilpel?
And these issues have come up before the task force before from time to time about in-camera review. So I guess where I am now moved to is understanding whether the regulations that were being promulgated, which are the subject of the instant request, were commission regulations in more fully interpreting the Sunshine Ordinance, Section 67.34, and referrals under that section, or whether they are more properly regulations under the Ethics Commission's general powers for handling complaints, which would be a C 3.699-whatever power, in which case they would be a different kind of thing. So arguably a related kind of thing, but it's like under what body of law were they promulgating these regs? Mr. St. Croix, can you speak to that for a second? Okay. So essentially what I'm saying is if it was a Sunshine Ordinance reg or a reg, to the extent that 67.34 of the Sunshine Ordinance requires that referrals from this task force be handled by the Ethics Commission and doesn't say anything further about that, if the Ethics Commission was promulgating regulations to interpret that section, I think arguably that would be a communication otherwise concerning or this ordinance and would be subject to disclosure under at least 67.24 B1.3. Okay? If, on the other hand, it was not, then it might not be subject to disclosure under that, but it also might be. So understand, the more we can understand about the nature of the, quantity and nature of these non-disclosed documents without revealing their content, but with giving us some color and flavor about them, would help us make a better determination. So I am, I guess, still moved to continue when we get there, unless there's something better that happens.
Members, Stevens?
Can you remind me how many documents were withheld?
Wasn't stated.
It wasn't stated. So I think my issue is based upon Mr. Grossman's records request. I'm trying to figure out what document that relates to his actual request that would be withheld under an attorney-client privilege that wasn't exempted by 67.2I or 67.24B1. And reading his requests, which is drafts or final versions of September 4th, 12th draft amendments to the Commission's regulations governing the handling of complaints related to the alleged violations of Sunshine Ordinance, and referrals from the Sunshine Ordinance Task Force draft amendments, which basically clearly would, any communication, even if it was, like you said, attorney-client privilege, would still be under 67.24B1, which is related to the Sunshine Ordinance or the CBRA. And then is B, the September 14, 2012 staff report referred to in the Folk Ring Commission notice. So maybe that's B is what I'm
Following is what it meant.
maybe B is what I need to follow up on. Like what could potentially is that? Maybe Mr. Grossman can answer what he thinks that is, or what that relates to, or what documents relate to that is. Sure. Yes.
Well, the regulations, unfortunately, there's a lack of institutional knowledge now, with the exception of 2 members. But we spent, a year and a half working on those. We had several meetings. I say we because I was directly involved in drafting suggested changes and serious changes as well. But to answer Mr. Pilpel's question, I'll just read you the preamble of the regulations they adopted. It says, pursuant to the San Francisco Charter, section blah, 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 the San Francisco Ethics Commission promulgates these regulations in order to ensure compliance with the San Francisco Sunshine Ordinance, Administrative Code, section 67.1 et sec. So the source of the law that triggered the requirement for these rules is in section, I think, 6730C or thereabouts of the Sunshine Ordinance.
Yeah.
So there's no question, it's not the Appendix C point 3.99 or whatever. This is where it comes from. And in addition, actually, the Ethics Commission's authority to handle complaints about violations of the public access laws, which are treated as, what's 6734? What is it? Come on. My memory's not very good, but it's willful violations is in 6734, and that says that those will be handled also. The word also isn't there, but that's what happens, is that those are all exclusively in the Ethics Commission. So its power to deal with these open government issues is in the Sunshine Ordinance.
No. I'm maybe you misunderstood my question. Maybe I'm misunderstanding your answer. My question is saying that your request, A, I'm right with you. I think anything withheld under your request A, I can't imagine of anything being withheld under your request A that could possibly legally be withheld in the Sunshine Ordinance under our current rules. When it comes to your B request, which is the September 14, 2012 staff report, I guess my question to either you or Mr. St. Croix, what is this staff report referred to in the Folk Ring Commission notice? What is that?
Well, if you're talking about number 2 in the submittal, the request,
yes,
the preparation, review, etc., of all prior drafts and final versions. Well, what happened was that after all this time, after this interaction on what should be, or how the task force felt what should be in there, and the Ethics Commission reviewed our comments and so forth, they called a meeting And I think it was within a week or two, I mean, at one of the meetings, I believe, in September of, what was it, 2014, September of 2012, to adopt them. And they just had them, and there was a report, and that was the end of it. And all of the public that used to show up simply had no way of figuring out what happened, and so it became an issue for people in my position who had worked all that time on it to find out what actually happened, and that was a very focused request. Prior and final versions of the draft amendment, staff report, that's all we asked for, plus whatever went into that through notes, letters, memos, and so forth. So it was very focused, very specific. It doesn't ask them to list anything. It just says, here it is. It's all concerned with public access, so it's exempt from, I mean, it's not subject to the exemptions that he's using.
So your answer would be the September, basically the September 14, 2012 staff report is as it relates to the September 24th regular meeting, which regarded the adoption of the Ethics Commission's handling of the Sunshine.
And I think that what's also important, would be important to me, and I don't know about the other people involved, is to find out what the commissioners saw before they voted on it, and whether they got any comments from the commissioners before they voted on it.
DCA 3, you were waving.
Through the chair to Member Sims, I think you also had a very particular question about what is the September 14th, 2012 staff report and be. And when the regulations were submitted to the commission, they came with a staff report that analyzed the regulations and comments and other things. So the report was directly about the regulations themselves.
Okay.
Can I interrupt? We don't know what changes were made in the staff report before it was public. And that's what we wanted to know. I also want to make one other comment. I know I have rebuttal. Well, I'll wait.
Does anybody on the task force have any other questions? Look both ways.
Rebuttals.
And now the respondent and complainant, in that order, get 3 minutes to rebut. So, oh wait, it's respondent first, right, Madam Clerk?
Yeah.
Sorry, you're waving?
Do I go first?
No.
He's waiving his right, so you are actually going second, but come on back. Do we make a note of that? Yeah. So,
Mr. String-Croy made a comment about our history. Our history goes back to 2009, when I made a series of record requests for disclosure of the files, the 27 files by which every task force referral was dismissed. I wanted to see what was in there besides the letter that said it's dismissed. He not only didn't give me any copies of any records, he didn't bother to answer it. So in 2009, I filed a lawsuit against the commission for those records. It was handled by a firm in Palo Alto, actually, the office. And the result of the lawsuit was they never filed an answer. They said, okay, you got all the records. Everything that we have, we're going to give them to you. And we got tons of them. And what are your attorney's fees? It cost the city $24,900 in that case. And it was not because I did anything. So that's really the history, and I can dwell on other parts of what Mr. St. Croix said to the press about the task force, but I won't do it here. I think it's pretty clear when you boil it right down that the request actually fell almost 100% within the exception on 6724. And that even if it didn't, I was still entitled to find out what was in the black box. How many? Which exemption are you trying to use? And I think the law is pretty clear. I don't care about some of the positions the city attorney's taken, but I think the law is pretty clear. They have to justify every exemption in writing, and you can't do it in a vacuum. I didn't ask for, give me a list or tell me where to go. Mine was very well focused. It was under 6721B, and the Good Government Guide explanation about not requiring a privilege log doesn't even apply to that section. Thank you.
All right. Do I have a motion to either find a violation of the Sunshine Ordinance 67, what was it, 21, 24, and 27, or motion to dismiss, or continue, or Member Washburn?
I actually have, I want to try something here. I may need some help, but I'd like to make two motions. The first motion is to find that the records that Mr. Grossman requested are public records and disclosable as near as we can tell from what we've heard today. So I move to find the records he requested, particularly the ones he didn't receive, to be public records under 67.24, and therefore they are to be disclosed.
I'm sorry, remember, what, can you either restate that? I'm not sure what you're asking on that one. But maybe Madam Clerk knows.
I move to find...
To find a violation of 67.24.
Okay.
Right. Well, I want to state it in the positive.
Okay.
Okay? Mr. Grossman explained the problem we have with a requirement to have 6 votes. A majority votes to find a violation. So the important thing is that, and please help me out if I'm screwing this up, but the important thing is that as far as we can tell, in my opinion, as far as we can tell from our discussion and what we know about this, the records that were requested are public records. They fundamentally have to do with this ordinance. So we haven't, in my opinion, been given any good reason for assuming that they're not disclosable. We don't know what they are. We can't tie, a certain type of document without knowing its content to any exemption. So that's what I'm. Does that make sense?
Second.
Motion is to find a violation.
I know we usually do that, but I'm saying that I'm mindful of, I think we can do this as well. And then the matter becomes, we have to enforce it and make sure that the documents are produced.
So we have one motion and a second. Did you want to group another one? And we'll see what happens and publicly comment on everything?
Well, why don't we talk about this one first?
Do you want to give us a hint about what's next?
No, I was...
Okay.
I was going to say that, there were documents withheld without specifying why exactly, although that may not be, the second one may not be necessary. I'm so used to thinking in terms of violations, but, it's our job as the Sunshine Ordinance Task Force to decide when documents are disclosable. So I'm just saying, we think these are disclosable. That's our finding.
Madam Chair,
Yes. Member Oka.
I'm going to move to find a violation under Section 67.24 because in listening to all the discussion here and my interpretation of what was requested by Mr. Grossman is that all the documents that he requested are subject to open government and subject to disclosure. So I totally agree with Member Washburn. I think we need to put it in terms of a violation, though. You know, frankly, I don't care about being nice. If it's a violation, it's a violation.
Madam Chair.
And you know, I find it very hard to understand why a violation cannot be called a violation.
Madam Chair.
Yes, Member.
Through the chair, I'd like to ask Member Oka, is this a substitute motion or is this an amendment to the motion already on the floor?
Or was it just commentary?
I'm making the motion.
He's making the motion. Is this a substitute motion or is this an amendment to the motion already on the floor?
Is there a motion on the floor?
Yes, there is.
Member Washburn.
Madam Clerk, can you reread?
Can I hear that motion restated, please?
Oh, I made the motion that we find the records that Mr. Grossman requested to be disclosable under 67.24. You know, the presumption is there was a violation. I'm just mindful of the problem that we've had in the past of the complainant having to bear the greater burden for proving his or her case.
Well, it sounds like maybe Mr. Oka was more like a friendly amendment to encompass both of yours, that a violation and that you're...
Hold that thought, everyone. DCA 3, you have something to add?
Yes, through the chair. I think there's a couple of strands being discussed at the same time. So one is Member Washburn would like to phrase her motion in the positive, and if I understand your intention correctly, I might suggest that the motion be slightly changed, that you're moving to find that the record is a disclosable public record under 6721B and 6724B1. 6721B is the provision that Mr. Grossman stated was violated in this case, and that in his view, it requires that there be a more explicit description of the records and why the exemption applies to those records. And 6724 provision that I mentioned was the one that says that even if these records might otherwise be privileged, if they are communications concerning the Sunshine Ordinance, then they're not exempt.
Okay, then I'll go with that. Yeah, it's more precise.
The other strand, however, is the issue that Mr. Grossman has put forward about how the voting procedure should move. I'm not sure that your proposal addresses that. I mean, it still appears to me to be a motion, and the motion still requires a majority support to pass.
It requires a majority, it's 6 votes,
Yes.
right? 6 of us.
Yes.
No matter how many people are in this room, it still
Correct.
requires 6.
Right.
If there's 6 of us, it requires 6.
That's correct.
Okay.
So, I would like to ask a question to DCA 3.
Yeah.
I just want to be clear on, I liked your suggestion. Where I'm comfortable is saying that what I would like to know is I would like there to be a fuller accounting for the reasons behind the documents that were not disclosed. Right? I am not, I can't sit here and say there has been a violation because I don't know what those documents are. Right? And so I just want to make sure, you mentioned two, you said 627.1, that sounded like it was more addressing that issue. And then you said there was a second part to what you were suggesting that said that something about these documents will then be, the presumption is that these are what's it called, documents that need to be turned over to the public.
Non-exempt?
Non-exempt, right, or whatever. My point is that where I am is I'm like, I would like to see a further, like, I don't know if there's violation because I don't know what these documents are. I don't know what these documents are. So I kind of like, I liked your suggestion, but I kind of liked half of it. So could you, I just want to, yeah, please.
So let me try to be clear about a couple of things. One is that I'm trying to help Member Washburn be as clear as possible to realize her intention. I want to clarify that my advice is that there is no requirement for a list of these documents and specifically how they're exempt. But because that is the intention of the maker of the motion, I suggested that she phrase it that there's a find that these are disclosable public records and that there's a violation of 67.21B, which, in the view of Member Washburn and the complainant, require that list. And separately, 67.24, B1, I believe it is where it's the respondent has claimed an exemption. It appears to be an attorney-client or attorney-work product exemption. Even if you could claim those exemptions under state law, if the communications in question or the records in question concern the Sunshine Ordinance, the ordinance says you can't claim it. So that's the category of records that we're focused on, and so I think it would be useful to have that in there.
Thank you for the clarification.
Member Sims?
Yeah, and I mean, I would be more like to separate each of those aspects out if we're going to vote. The first one being whether he is required an explanation of the for each of the items that have been withheld, and then in the second instance, a vote regarding whether these items are public records that that are not exempted by any of the relevant exemptions, because I actually don't need to see the records to know that they're public records, because based upon his request, since his request only has to deal with the Sunshine Ordinance and only has to deal with, if it was withheld based upon his request, because his request is limited in scope to the Sunshine Ordinance and to the Public Records Act, then the document has to be disclosed. So I don't see how. That's why I said earlier, like, I don't see how the document isn't disclosable.
Madam Chair, again, a matter of procedure here. Through the chair, I wish to repeat my question to Member Oka. The motion that you, or what you brought forward a few minutes ago, was that intended as a substitute motion or as an amendment to the motion that is on the floor?
If it will resolve this, we'll put it as an addendum to
As an amendment.
Member Washburn's.
Okay. Second accepts. Does the maker accept the amendment?
I do. I'm just trying to be mindful of now what Member David and Member Sims, their concerns, and whether it might not make sense to have two different motions.
Well, yeah, what?
I mean,
I'm going to suggest we have two motions, yours and then I'll make mine. So I'll withdraw what I said for the time being, and we'll vote on Member Washburn's motion.
okay.
Member Washburn?
Okay. This is second. Yeah.
Second agreed.
Okay. So we're back to my original motion, which right now reads that we find these records to be disclosable under 6721B and 6724B1.
B1.
So now we can go with that, or I'm listening to, those are really two distinct issues, and it might make sense to to have two separate motions, and we could also, we can state them in the positive, or we can state them in the negative. I don't know that it matters really much. Mr. Grossman, over time, has helped me see, although I don't fully see because of certain dyslexias I have and twisting things upside down sometimes. But, I think it might make sense to have two separate motions. One regarding, do we want an accounting of these are the sorts of documents, these are the exemptions that apply, that issue, and then the whole other issue is regardless, these documents have to do with sunshine and therefore are disclosable. So I think I'd like to say that I'm fine with having two separate motions, and I'm happy to put them forward. I would like to, first motion would be to find that these documents are disclosable under 6721B, or 21B, and that also they're disclosed, a second motion, these records are disclosable under 67.24B1.
Oh, so there are two. Okay.
Two motions, yeah.
Member Pilpel, did you have a comment?
Yeah, I understand Member Washburn's perspective on this. I'm not sure that I agree. I'm not sure that I disagree. I don't have enough information at this time. So I am, again, moved to continue the matter. So I will so move as a
Substitute motion.
It's not a substitute. It's not a privilege. What is it? Whatever. Under Robert's rules, it's a higher priority motion that would continue the entire matter to the next meeting to allow some further information from ethics so that I have at least some better information to vote upon. And if that fails, we can certainly go back to the main motion, which I understand was divided. I think a member has a right to divide the question, and it sounds like that was the request made. I am concerned, however, that if my motion fails, that the two motions to find a violation may not, either one may not gather 6 votes tonight. So we may end up not taking any action. So I just wanted Member Washburn to consider that.
Member Washburn?
Okay, well, I'm thinking...
Point of order.
And I think I need a second.
Oh.
I'm sorry?
I think I need a second to continue the matter.
You don't have one yet, but I believe Member Nee had a point of order
Well, that was
comment.
my point of order.
Oh.
Second is required.
I'll second.
Okay, we have a second.
Okay, I just wanted to say that now I'm thinking by phrasing the motions the way I did, saying that these are disclosable, if these pass, then the respondent would have to disclose the records or explain why they're not disclosable in some way that would convince us. So by passing these motions, that I believe would accomplish the same thing as a continuance. Because by continuing this, you're saying we would like the respondent to explain why these things are not disclosable. So I think by passing the motions that I'm putting forth, that accomplishes the same thing. We get some more information. Mr. Grossman either gets the documents he requested, or ethics comes back and says, okay, we're not disclosing them, and they explain why. Under 67.27, they're supposed to explain why they're not disclosing them.
Member Oka? Yes, Member Oka.
I know that a motion to table, there's no discussion, but is the rule similar on a motion to continue? Mr. Tate?
I was just looking that up.
Currently, there's 2 motions on the floor. You can table a motion but not to continue a motion.
Right. Because tabling is just setting aside temporarily.
The question is whether discussion is allowed on a motion to continue. I believe it is.
On the first motion, yes. Currently, you have two motions on the floor. So first would be to deal with Member Washburn's motion, have discussion on that, make a vote, then go to Member Pilpel's motion.
No, motion to continue takes precedence.
Yeah.
I've never
Yes,
done
it
that.
does. I know that. All I wanted to know was
Yeah, it's
whether there was discussion allowed on a motion to continue. And if there is, then fine.
That I'm not aware of. I can't answer that question.
If we are allowed to discuss, I'd like to go
Oh,
next.
sorry, Member Highland, you were next. Sorry.
Just discussing your motion to continue and presumably continue to get more information from the Ethics Commission and John St. Croix, I feel uncomfortable in that position. That's like appointing us a special arbiter, whereas this goes beyond that. This goes to disclosing the information in the first place. So why not just cut to the chase, go with the motions that there was a violation, and have them disclose it? It would seem, I'm sure the Ethics Commission was very careful in determining why they thought these documents were exempt, but in the end, if they're related about sunshine, which presumably it would have to be, it's very, very clear cut here.
Let's go with Member David and then Member Pilpel.
Yeah, so here we are again. So I have a similar concern that Member Highland just raised, that if we continue, that do we have any assurance that we will get the information that we're looking for from the Ethics Commission, if we continue and say, but at the same time, I don't agree that I think saying that, well, let's find in violation to get the information, I think finding someone in violation of the Sunshine Task Force is to me, it's a very serious matter, and it's not to me, a means to an end. So, yes, I would like the information. Yes, I have no idea if the Ethics Commission would be willing to provide it if we don't find them in violation. And so, which is why I'm most comfortable with kind of splitting the baby and going, okay.
It's disclosable.
Yeah, but I'm just a little I'm uncomfortable with saying that, well, let's find them in violation so that we can get the information. That feels a little. We should find them in violation if we feel there's a violation. I'm sorry, that's it.
Oh, Member Washburn.
Well, okay, that's a good argument for the way I phrased it, although that wasn't the main reason I did. So we're not saying that they're in violation. We're just saying that from what we know, from what we've heard today, we believe these records are disclosable. So now, they'll have to disclose them unless they come up with justification for withholding that passes muster with us, since we're, the ones who are adjudicating this. So we're not finding them in violation. We're just saying these records need to be disclosed.
Member Pilpel, you had something?
Actually, I liked the comment a couple of minutes ago about Member David and Member Pilpel, so I feel like I've already been divided. Never mind. If we, to Member Highland in part, if we don't have enough information, then I still am inclined to get more information if there, and I agree with Member David on this point, if we believe there's a violation and the record should be disclosed, then we should so find. If we don't believe, then we should not so find, and if we don't have enough information where we can actually get information, or we reasonably believe that we can, we should try to do that so that we can make the best decision. I think finding a violation when we're not sure and asking for justification after the fact is not a good course, because in fact the documents should have been disclosed or justification provided for not doing so already. And if there was a sufficient basis for doing that, then there's no violation. And if there wasn't a sufficient basis, then there may be a violation. So that's kind of where we're at. I guess my question at this point to Mr. St. Croix, if you could join us for a moment, if we were to continue this matter, would you be able to review the documents at issue and provide some more information, or are you not going to be able to tell us anything more about it and we may as well just go with what we have now? That's kind of the issue before us.
I'll do that.
The first or the...
Yeah.
I'm sorry, I didn't know there was a bifurcated question there.
If we grant a continuance, would you be able to come back with more information?
I can come back with a description of the number of exemptions and why those exemptions, or why those documents fall under the individual exemptions.
And how many documents, for example?
I just said that.
Okay, got it. Okay, cool.
Madam Chair.
I had a quick question to Mr. Popel.
Hold that thought.
Let's say we go down that road. Would that information come to us?
Yeah, right here next meeting.
We
or in
continue
advance.
this item 1, 2, whatever, to the next meeting. Mr. Grossman, I want to give you a chance. Did you have a question? You got to speak, so you get to speak.
First, the motion should be, as I suggested, that the undisclosed records are exempt from disclosure under whatever sections, exemption sections apply. That way, if they are exempt, you vote that they're exempt, and if you get 6 votes, Mr. St. Croix is relieved of any further obligation. If he doesn't, then that ends it. There's a determination. And if you look at the ordinance, that's what it says. You're not here to find initially whether there's a violation. That word does not exist in 6721E. It says, if a custodian refuses and so forth, the sunshine for a determination whether the record requested is public, i.e., not exempt or exempt. They shall inform, the task force shall inform the petitioner as soon as possible and within 2 days after its next meeting, but in no case more than 45 days from when the petition in writing is received. I filed this in November of 2012. So Mr. St. Croix appears before you, and you ask him, how many records are there? I don't know. Did you look at them? No. So which exemptions would apply to which? I don't know. And now you want to continue it so he can do that? What have I been doing for the last 7 months? Admittedly, you know now through the package that I took a month of vacation, but other than that, I could have appeared almost at any meeting. So I don't see the continuance is just going to aid and abet this behavior. And I don't see it, to be honest with you.
Thank you.
I mean, and the fact that none of you, except the 2 at this end, have been at task force meetings for years. In fact, in your case, I think you didn't go to one until you applied. The point is that the task force forever, you had your hearing, it did its job, it made its finding, and the respondent had a chance to comply with the determination, the order of determination. The order isn't a violation, it's whether the records are exempt or not. So Mr. Popel, who's looking for some elbow room here, I think is adding to the confusion rather than helping you focus on what the real issue is before you.
Thank you.
Thank you.
Madam Chair.
I'm going to go with member Nee, and then, let's go this way. DCA 3, and then member Nee.
Through the chair, I want to address 2 issues. One is it's sort of a basic ground rules for a hearing that the parties should be prepared to present their arguments and their evidence at the time of the hearing. So there certainly is no, reason that the task force could not hear this and decide on what was presented here today. And it also is typically in court hearings and other proceedings, if a party is not prepared to present their evidence and their arguments, then they take the result that comes. So that's just one point. But I want to address Mr. Grossman's proposal and rationale for the voting procedures. If I understand correctly, Mr. Grossman has suggested that you make a motion that the records are exempt as claimed by the respondent, and suggests that if the motion fails, therefore, there is a determination by the task force. In my view, this is a sleight of hand. There has to be an action by the task force with a vote that supports that action with a sufficient majority before there's any action by the task force. So if you have a motion as suggested by Mr. Grossman and it fails, that means the motion fails. That's all it means. And if you would like to make a determination, you have to have a motion that is phrased as what your determination is, and it has the support of a requisite majority of the task force.
Member Nee?
Yes, I just wanted to ask DCA 3, on the motion to continue, would that be considered a procedural motion or a substantive motion?
Through the chair, motion to continue is a procedural motion.
Okay, so in this case then, motion to continue would require 5 rather than 6 affirmative votes.
Correct.
Can I make a quick update?
Member.
I really don't know what Mr. St. Croix could bring back. He would have to first say, okay, this document is responsive to his request. Even though it's responsive to his request, it's covered by attorney-client privilege. He's just going to say it's covered by it's responsive and it's covered by attorney-client privilege. He's just going to go down the line for every if it's 10 documents, if it's 100 documents. Like, that's what I would do. And then he still doesn't have to disclose it under kind of that rationale. Even though if it's responsive, it's under the exception that it has to be disclosable based upon his request. His request is narrowly tailored. It's not an open. If his request was through the roof and so vague and ambiguous, I could understand. But this is not a vague and ambiguous request. This is a narrowly tailored request regarding information of the Sunshine Ordinance Task Force and the Public Records Act. So, and it fits into the exception of the attorney-client, the exception of the attorney-client privilege exception, which allows him to not produce those documents. But based upon the Sunshine Ordinance, he must produce those documents. So, don't really know much more he can add to us.
So you're saying that you're agreeing that they're exempt under attorney-client privilege. This just made a big circle for me. Did I miss something?
No. I'm saying that if these documents were called as responsive to his request, and they were then withheld based upon attorney-client privilege, based upon his request, they could not be withheld for attorney-client privilege based upon 67.24B1. Therefore, them being withheld is a violation of the Sunshine Ordinance Task Force, and they are publicly disclosable documents. So that is my argument.
So are you saying that if they were deemed to, I should maybe ask DCA 3, if they were deemed to be under attorney-client privilege, then we wouldn't even have them in this room? We wouldn't even be having this discussion today?
No.
I know I went a little far afield here.
To the chair, that's the exemption that is my understanding, that's the exemption being claimed by the respondent. But there's an exception to that exemption under the Sunshine Ordinance if those documents concern the Sunshine Ordinance. So, for instance, if it might be attorney-client communications, there might be attorney-client communications between the attorney and the Ethics Commission about the Sunshine Ordinance. And if it wasn't about the Sunshine Ordinance, then under state law it would be exempt from disclosure. But if it is about the Sunshine Ordinance, the ordinance itself says that it's not exempt and must be disclosed.
So
And that's what these are?
Yes, that's what they are.
So in my view, even if, you know, even if Ken Starr himself gave the advice to the Ethics Commission that don't disclose this document, or Justice Thomas of the Supreme Court gave his advice that don't disclose these documents under the Sunshine Ordinance Task Force, guess what? It's still discoverable. Outside counsel, inside counsel.
In litigation.
I go on and on.
Member Pillow?
Although that's in a litigation context, and this is an administrative proceeding. But, Mr. St. Croix, let me try once more, because I'm not sure where we're headed with this. Do you know anything tonight about the documents that are at issue? I think everyone's agreed that they are, whatever they are, that they are responsive to the records request, but you're claiming that they are exempt. Can you tell us anything tonight about those documents that would help the discussion? Were they between your office and the city attorney's office? Were they related to how you develop regulation? What can you tell us?
No,
something?
sir. I would have told you already if I knew anything. I'm sorry.
Okay. Then, I'm sorry, then...
I call a question.
Okay, one moment. If I still have the floor for one more shot.
He calls the question, all right?
I am tired of going round and round and not coming to any kind of conclusion. I call the question. We either vote this down or up. We either continue it or don't.
Okay.
We have a motion on the floor.
Public comment.
Oh, I forgot about that. It's right here. Okay, can we review the motion and then we'll call for public comment?
Motion is to...
No, it's to continue.
Motion is to continue.
Yeah.
Okay, so that one superseded Member Washburn's. We have a motion on the floor to continue. I'd like to take public comment. Seeing none, no, I'm just kidding.
On the entire matter, on both motions.
Yes, this is one opportunity for public comment on both motions.
Both motions, I heard you said the motion on the floor was to continue.
And there's also a further pending motion, which may be divided.
Two motions.
So, you know, there are actually like three pending motions in order. This is the opportunity for public comment on the entire matter.
I thought there would be three votes on three motions, and the calling of the question was on the question of whether to continue.
Yes, and therefore there's public comment.
I'd like the chair to clarify what the chair has in mind.
DC3, can you help me with this?
Do you have a question for me, Madam Chair?
Yeah, can I put these all three in one? Or should I mean, if we continue this, then the other motions become moot. So that's where I'm going with this.
Madam Chair, the ordinance and the Brown Act require that there be public comment on each agenda item. It's within your discretion to have public comment on each motion if you choose to do so.
Yes. So as I understand it, I called the question on the motion to continue.
Mm-hmm.
That's what I called the question on.
I'll be taking public comment.
Now, public comment on that.
Okay, public comment on the motion to continue. We haven't heard much from the public today, so go ahead on this motion.
Thank you, Madam Chair.
You have 3 minutes, I believe, right? Okay.
I I would like to support Mr. Grossman, though I'm not involved in this case nor actually familiar with it except for some parts that I've heard discussed. The endless provision of additional time and more time and more time, and gee, if we did this, would you maybe squeeze out a little juice from that squeezed out lemon more, I think is wrong. I think, as Member Sims said, and I think your DCA 3 said, you go with what you've got. The parties have had ample opportunity to provide all the information that they're willing to give and that would support their case. And I think that you have plenty of information here to give you an understanding of what's going on. If you were to go with a continuance, you would be setting a kind of pattern or precedent where procedures could be dragged out endlessly as people would squeeze another drop out of the lemon and say, well, if you gave me a continuance, I might give you a little more information, and if you take another month, I might give you a little more, and then if you ask me for something else that I wasn't prepared for, a little more, and so on and so forth. I don't think that's a good way to go for yourselves, and certainly not for the public. So that's why I would agree that you have plenty of information here, and you should, as they say in the newspaper biz, go with what you got. Thank you.
Do we have any other members of the public who have not commented on this?
I would support that a continuance not be made. I found in my own dealings with the Ethics Commission that a criminal case was filed against me. I did an online public record search around March 6th of 2003, and I found a civil harassment case filed against me across the street at 400 McAllister Street, and included in it was a declaration of a Catherine Agamundo, who apparently is an investigator with the Ethics Commission. The case was dismissed. I wasn't served. It remained open for 3 months, but I went nonetheless, even though I wasn't served. Nobody appeared. There was no attorney. Catherine Agamundo wasn't there, and the case was dismissed. So I would suggest that I don't even know who this person is, so I would support not continuing the matter.
Thank you. Do I have any other public comment? Seeing none, public comment is closed. Go to a vote.
You have 3 motions on the floor?
Yeah, I know.
So
Motion to continue.
the motion is
Motion
to continue.
to continue.
Okay.
Let's
On a
just
motion
break
to
them down.
continue, okay.
One at a time.
On a motion to continue, Member Nee?
No.
Nee, no. Member Washburn?
No.
Washburn, no. Member Pilpel?
Aye.
Pilpel, aye. Member Sims?
No.
Sims, no. Member David?
Aye.
David, aye. Member Highland?
No.
Highland, no. Member Oka?
No.
Oka, no. And Chair Fisher.
I'm going to say no.
Chair Fisher, no.
I was really swayed.
6 noes, 2 ayes.
Go with your heart.
It only needed 5 to pass,
I-
because it was a procedural.
Oh, I thought it was the...
We got 6
Well,
no's.
then y'all know where my heart is. We have
Motion fails.
6 noes and 2 ayes, so it fails.
Right.
Well, she usually, Madam Clerk always says that. I don't want to steal her thunder.
What is the next motion you'd like to vote on?
Member Washburn?
The motion to find that the requested records are disclosable under Section 67.21B.
Do we have public comment? Oh,
You're right.
why, we broke them all up, so.
I get to comment?
I don't believe you do. It's only people who have not commented. Okay, seeing none, public comment is closed.
Okay. Member Nee?
Yep, public comment.
Your public comment.
Right.
I'll give us 3 minutes. You have 3
Dear
minutes.
Warfield, I just wanted to support that. I think these are disclosable. I think you've heard from your own attorney and others that the records are disclosable based on the limited request that was made by Mr. Grossman. Thanks.
Thank you. Any other, seeing none, I'm going to ask Madam Clerk to
Close public comment. Close public comment. Close public comment.
public comment is now closed. Can you call the vote?
Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
No.
Pilpel, no. Member Sims?
Aye.
Sims, aye. Member David?
No.
David, no. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Chair Fisher?
I'm going to say aye.
Chair Fisher, aye. You have 6 ayes and 2 noes.
And
No.
no.
One
and
more.
Chair Fisher, I would suggest that the next vote is on Member Washburn's bifurcated motion to find a violation of 67.24B1.
I don't think that was the motion. I think it was to find that the records are disclosable.
Disclosable. It wasn't about finding a violation.
Under 67.24B1.
It was specifically stated in the positive. And so this next motion is regarding the fact that the records requests were about records having to do with this ordinance. Therefore, regardless of any sort of exemptions, they're disclosable.
I'm sorry, through the chair, Member Washburn, can you repeat the motion, please?
The motion is to find that the requested records are disclosable under Section 67.24B1 of the ordinance.
Thank you.
Public comment.
Do I have any public comment?
Up to you.
I'm offering it. Do I have public comment on that motion?
Peter Warfield, I think you're proceeding in a logical and sensible way, and I support the motion. Thank you.
Any other public comment? Seeing none, public comment is closed. Can we have a vote?
Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
No.
Pilpel, no. Member Sims?
Aye.
Sims, aye. Member David?
No.
David, no. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Chair Fisher?
No.
Chair Fisher, no. 5 ayes, 3 noes.
Fails.
You cannot do that.
Why?
You just voted
Can't.
that they're public and fully disclosable,
Okay.
and now you're saying they're not?
Okay. Madam Chair?
Yes, Member.
If we found a violation with at least the first section, I think you need to decide where to refer this matter now.
That's what I would like to do.
Very good.
Do I have a motion on where to refer this matter?
No motion, that's your call,
Oh.
and you just make an announcement.
I think I'd like to refer this to CA3?
Madam Chair, Mr. Grossman's point is well taken. The motion in both cases was that the records were disclosable.
Yeah, I'm really torn on this. Okay.
And there was a sufficient votes to pass the first one, but not the second one, so they're inconsistent.
Yeah, I was really torn. Madam Clerk, can I how do I go about changing my vote? I don't...
Madam Chair?
Yes, Member Nee.
Well, there was only one among us who was on the prevailing side in both motions. That was the chair. Therefore, I think that under proper procedure, the chair would have to be the one to move that the two motions be brought back as a combined motion, and that the vote be retaken on that basis. I think the chair is the only one who can do that, because the chair was the only one on the prevailing side of both motions.
Yeah, I was just really caught up in the whole squeezing lemon. I just feel like I was being...
Or the chair can change her vote on the second motion, which would take care of it.
So
I would... Member Philpo.
I would suggest that the chair can request that we rescind the vote on one or the other or both, but so to that extent I would agree with Member Nee, but I don't think that the motions get combined. I think that they were already properly divided, and there's no basis to recombine them. So I think it's up to the chair if you want to change your vote on one or the other or both, to request to rescind the vote and recall the vote.
I want to see if everybody is as conflicted on this as I am, so I would like to run both votes over again.
So then you're making a motion to rescind both, and we need a second, and we can do that without objection, and then vote on both questions.
I'm polling the jury, so to speak.
I'm sorry. I'm confused why we're rescinding the vote. The motion that did not pass did not find that the records were yet public records, in my view. We found with the first one that there was a violation, correct?
We found that they were disclosable.
That they were disclosable, right?
I'm fine with that. Yeah.
We found that they were disclosable. In the second one, we found what?
That they were disclosable, but that motion was voted down.
Exactly. So we have already a first finding that the records are disclosable.
What we have, Member Sims, what we have are two motions that, because they reached different conclusions, the two motions therefore conflict.
But only one motion is passed.
That's correct.
And
because the other failed, therefore you have two motions that conflict.
I feel like the other that failed is irrelevant.
There's only one that actually is...
I mean, can we get DC?
Let's go with DCA 3.
Yes.
You're saying there's only one motion that's effective, the one that passed?
The one that passed.
Yeah.
DCA 3?
Yeah.
So each of the motions are phrased as finding the records disclosable under the separate provisions. 67.21B, as it was articulated by Mr. Grossman and by the maker of the motion, would require that there be a listing of the exemptions and the documents and how the two things relate to one another.
Yeah, that's the first motion, right?
Yes.
That's the one I was going with.
If the intention was not to say that they're necessarily disclosable, then that motion should read differently. But as it reads currently, it says that they're disclosable records. The records cannot be disclosable if they're exempt from disclosure. And the second motion was about the basis for the exemption, and it failed. So Mr. Grossman is correct. There's a conflict between the two.
Then I misunderstood him, because I was going with just to explain myself, with the first one, with the list, they should be disclosed. I want to hear more about this. And then the second one, I was concerned with the attorney-client and privilege. So maybe I misunderstood.
So
I didn't know that they conflicted with each other. I didn't know that they were poison pills with each other. I got Member Washburn first.
Yeah. When I agreed to split this, I was doing this because I was hearing members having two distinct issues. One was a desire to know more about the records that were withheld and the basis for it. And that was the basis for continuing it. So that's why I separated that out. Now, but I'm of the mind, I think the argument is compelling that Mr. Grossman was asking for records specifically relating to this ordinance. Okay, so 67.24B1 addresses that. It says it doesn't matter if these records can be claimed to be exempt under attorney-client privilege or work product, because they deal fundamentally with this ordinance, which they do, because Mr. St. Croix said they were responsive to Mr. Grossman's request, which was for documents about this ordinance, then they cannot be withheld. They might be exempt for other reasons, but they can't be withheld because they have to do with this ordinance.
Okay, and that's the second motion.
Right, and that one is, to me, compelling. And to the other members who voted to support it. But I was being mindful of people wanting to know more. Here they are saying, we have some documents, we've decided that we don't have to tell you anything about them. They have to do with what he wanted, which is about this ordinance. But, so I'm operating here in the interest of public records.
Okay.
Open government and sunshine. So trying to get the most as I can out of this.
Member Nee?
I'd like to ask DCA 3, even though I was not on the prevailing side in the second motion, would it be out of order for me to make a motion that both of those motions be rescinded and put to basically put to a revote? Would I be out of order in doing that?
No, we're headed there.
We're going there.
Member Nee, I think you yourself have said that's out of order on multiple occasions, and I agree with you.
Okay.
Great. So, Madam Chair?
Yes, Member Pilpel.
Okay. Although Member Washburn is in the room right now. The way I'm reading...
She's in the washroom.
She's in the washroom.
Washburn is in the washroom.
I'm surprised you didn't get that.
I think that 67.21B speaks more to the justification for withholding, and if that was insufficient, that's one section of potential violation, and 67.24 is really whether the documents were properly withheld. So if a member feels that the justification was insufficient, they should vote for the first motion, and if they feel one way or the other that the documents should have been provided, then they should vote for the second motion. They should vote for one or the other or both, and I would suggest, notwithstanding whatever, that we rescind the vote on both motions and take the vote again. And I think that if a member makes the motion, if the chair deems it in order, if there's no appeal of the decision of the chair, we can go ahead and do that.
DCA 3?
Am I incorrect that Chair Fisher has called for that, being on the presiding side of both?
I'm going to make it even shorter. I'm going to rescind my vote, then I have a recommendation for how we're going to handle this. Can we do that?
Let's hear it.
No?
What is your question? I'm sorry.
On the second motion, as I was conflicted, I will, and I don't want to set us up where we've got two things conflicting with each other. I would like to change my vote, and then the motion will pass, and then I have a recommendation.
Chair Fisher, the procedure for that would be for you to move to rescind the vote on that second motion, get a second, and then you could move to do that, and then you would take the vote again.
I move to rescind my vote.
Second.
Can we take the vote again?
First, you have to vote on the motion to rescind. You can take it without objection.
Let's take that without objection.
No objection.
And now you move to the vote again on the second motion.
Can you call the roll?
The speaker, just speaker, public speakers. There's speaker, okay. All right. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
No.
Pilpel, no. Member Sims?
Aye.
Sims, aye. Member David?
No.
David, no. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. Chair Fisher?
Aye, so it passes.
6 ayes, 2 noes.
So can I make my recommendation now?
Why?
What? I would recommend that this matter go to the Compliance and Amendments Committee, since they have way more experience on this. And so it would be taken up at your next meeting.
Yeah. If we can get it all together, sure. Yeah.
See what happens when you make a motion. It comes back to your committee.
No, I was expecting that, actually.
When we're done with this, can we go to item 4, public comment, or take a break?
I would ask for a 5-minute recess, Madam Chair.
Okay, let's take a 5-minute recess. We don't need a motion, not doing. That means we'll be back at 6:35. We have quorum. They're finishing. We have quorum. We're fine.
Yeah, who's here?
It's just Member Sims, DC. He'll be here in a moment.
Oh, right, but let's have public comment.
Yes. Okay, I'm reconvening the June 5th meeting of the Sunshine Ordinance Task Force. Do I have any public comment? General public comment? And just give me 1 second, Ms. Tisch. So, general public comment, you have 3 minutes. Members of the public can address us on matters within our jurisdiction, but that are not on today's agenda.
This is general public comment.
Yes.
And I want to direct you to a Superior Court of California case number CCH 13574399, which I found doing a public records search under my name around the first week in March of this year. When you deal with the San Francisco Arts Commission, you know, after so many years, you're just always on the defensive, and from time to time I do public record searches. I found this action a week prior to a hearing where they alleged 6 violations on a street artist permit. They didn't even notice me of that correctly. I was in the hospital at the time, but nonetheless, this case remained open and unserved on me until May 28th, 2013. I did not need to go into 400 McAllister Street, but I did. Howard Lazar was not there. No one from the Sunshine Task Force was there, and no city attorney was there. The 3 declarations, the one you see in front of your screen is a declaration of Howard Lazar claiming that I'm stalking him and harassing him. Yet in the attachments or affidavit he filed, I couldn't find any evidence to this. If this event happened in December of 2012, why is he filing in March, just prior to a street artist hearing? The case was dismissed for lack of evidence, and it goes to the credibility of Howard Lazar and a Catherine Agamundo. Basically what happened is the Arts Commission does not ever pick up the phone, and they rarely respond to emails. This has been going on for more than a decade. It's impossible to do business with them. And I went up one day in December to speak with Rebecca Krill, Howard Lazar's boss. She wasn't there. I waited on the corner in a coffee shop for about 20 minutes. I saw Lazar standing on the corner there looking around. I just walked down Market Street, got on a cable car, and stopped on Powell Street, saw a friend, we were talking, Lazar popped up, and went to the ferry building, had lunch, went home. He made an entire scenario about how I stalked him that day, which was not true at all. This case, in my view, though I haven't had any conversation with Lazar in well over 20 years, was an attempt to deny me my First Amendment rights of being able to come here to talk, to file sunshine requests, and to file an appeal, which is pending and
Thank you.
across the way.
Thank you.
Those are serious charges. Somebody should look into it. Thank you.
Do I have any other public comment?
If you could let me know in 30 seconds. I'm Peter Warfield, Executive Director of Library Users Association. I have a couple of points. First of all, I'd like to speak about something that's not on the agenda, as this item is for. In a previous hearing today, the chair said something that I thought was very nice. And it ought to be something that is part of your procedure as you go through with hearings. You said, Mr. Grossman, he got to speak, so you get to speak. This was after you had asked a question of Mr. St. Croix, and I think quite appropriately were willing and prepared to offer Mr. Grossman an opportunity as well. Something that I've noted over many years is that the task force will, on various occasions, ask whatever factual questions, opinion questions, and have the respondent reply and not give the complainant a chance to, if they think there's need to, set the record straight or comment on whatever that was just said in response. Now, I know this gets into larger questions of procedure, but I think that in terms of fairness, when you ask a question, what are the hours that some place is open, you should also give the other person to say that's right, or actually that's not correct with respect to this and that. So I appreciate that, and I hope that you'll think about doing this on a more regular basis. Your deputy city attorney said something was a procedural motion, and so it only needs a majority of those present. He actually said 5 votes. I would like to know, and I'd like there to be some formal note with respect to what is a procedural motion and on what basis procedural motions require lesser
30 seconds.
votes. Finally, Library Users Association filed a complaint against Supervisor Campos more than a year and a half ago, or approximately a year and a half ago. The case was heard in April 2012. An order of determination was made. It was written in May. It was sent out in June. A year ago. Why isn't follow-up on this agenda, since the EOT forwarded it here for further consideration, including additional violations? I think it's really unconscionable, and I would like to ask why.
Okay, thank you. Is there any further comment?
Howdy. I filed a complaint maybe about a couple months ago against the local homeless coordinating board, and I'm just kind of like wondering what the next step is, because I'm one hearing and it's going to be going to some committee or council. I don't know how often you meet, I plan on being out of town for a month, but I'm just wondering what's going to happen next. I think the other thing, too, is before this body there was another body very similar. Not similar, but there was a bunch. It was a different body with different members. And they were talking about modifying the Sunshine Ordinance, and I'm wondering what's happening with that process. Is it complete? Are y'all trying to push it forward? Or what's going on with that?
Member Washburn, do you have a comment?
Mr. Pitts, I can't answer your first question, but regarding amendments to the Sunshine Ordinance itself, this body, a couple of years ago, over a period of several years, developed some suggested amendments. The full task force voted to approve some that we wanted to see carried forward. The constitution of this body has changed. And right now it's not on the agenda of this body. There are other people working on possibly bringing the matter to members of the Board of Supervisors or to using the initiative process. But right now this body isn't actively looking at amendments. We had some that we wanted to see go forward, but the current body hasn't taken that up.
Thank you, Member Washburn. Member Pilpil?
To Mr. Pitts, and actually if someone could close the document on the screen, it would help. It's a bit distracting. To Mr. Pitts, when exactly were you planning? Oh, hey, that's good. When were you planning to be away so that I know not to schedule it when you're not here?
I'll be leaving for about a month from tomorrow.
Oh, okay. All right, so about 6/6 to 7/6? Plus or minus?
I guess. I'm unsure, but...
Not in the month of June. Okay. And I tried to get to the local homeless coordinating board meeting on Monday. I did not make it, so I'm going to try to go to the next meeting and just see how things roll over there. So that might help. But we will hear it when you're present, and thank you.
Thanks.
Got it. Thanks.
Is there any more public comment? Seeing none, public comment is closed. What?
Mr. Warfield, the person who makes the agenda is the chair, and she's not here tonight, so she's the one who you would need to ask the question as to why it was not.
I'll refer your question to her. I'll take that item. I did write it down. Sorry about that. I didn't want to speak for Chair Grant, who will be here next month, so I will refer that to her. Okay, seeing none, public comment is closed. Next item, Madam Clerk.
File number 12059, complaint filed against Suprit Pabla, Local 1022, against Human Services Agency for allegedly failing to provide records requested relevant to the representation of the bargaining unit's employees.
And I believe jurisdiction was accepted by both parties, Madam Clerk?
Not contested.
It was not contested.
So you need a motion to find jurisdiction. I would so move.
Second.
Can we call this passed without objection? Okay.
Public comment.
And I'm getting there. And
Public comment on jurisdiction.
I'm getting there.
Oh, okay.
Before we vote?
On jurisdiction, on the motion.
Okay, so I'm going to ask for public comment on jurisdiction. Seeing none, can we pass without objection? And, okay, so the respondent and the complainant each get 5 minutes to make their case. The respondent is not here, but has provided a document for us, and this is new even to me. Do we just hear from the complainant first?
Yep.
Miss Pabla, you have 5 minutes.
Thank you. My name is Supreet Pabla, and I'm a field representative. I work with SEIU Local 1021 in San Francisco, and I represent HSA Human Services Agency members, about 1,600 members. And I have filed or requested information in the past, and the agency has not been forthcoming with information. So in this instance, I requested information under the Myers-Milius-Brown Act, and also I cited the Sunshine Ordinance. I did receive a late response, but it was lacking the information that I requested. And after not receiving that information, I sent an email indicating that this was requested under the Sunshine Ordinance, and that the agency needs to comply and send the information. After which time I didn't receive anything, I contacted the Sunshine Ordinance, I believe Andrea Osbury, and informed her that I would like to file a complaint, and I think the mediation process began at that point. I received a new response to my original information request that was sent in September 2012. I received a new response in December, but it was still lacking the information that I requested, the public documents that I requested. So that's where we're at today, because we were not able to mediate. So I asked for a formal hearing a couple of months ago, and I could not make it to the May meeting, so I requested a continuance until June. And I also wanted to note that I did not know that that you could submit something in writing. As far as from what I've read, the complainant and the responder needs to be present or send a representative. And also I think that the respondent's letter was lacking the reasoning for not responding to my information request. Thank you.
Thank you. So do I have any members of the public who would like to introduce facts and evidence in support of the complainant? Okay, seeing none, I'm going to open it up to the task force to pose questions to the complainant.
Madam Chair?
Yes, Member Nee.
I'd like to ask the complainant to approach, please.
Yep. I figure everybody's going to ask.
Thank you. Have you seen the memo that came to us today from the Human Services Agency?
Yeah.
Okay, where Mr. Rohr is saying there are no additional documents in response to SEIU's public records request. So I guess my question is, of all of the documents that you requested, are there any that you have not received? And of all of the, one of the things that we have to deal with here is that an agency may not be forced to, not be required to create a document. Mm-hmm. So what they're saying is all of the documents that they have that are responsive to your request have been given to you. Do you take issue with any of that? Are there any documents that you have requested that are missing, and do you know in fact that those documents exist?
Yeah, for example, in my request number 5 was, or sorry, let me get this right, number 4, where I requested information about how many days Debbie Jeter spent in training outside of San Francisco, and we requested dates from September 2011 to September 2012, and how much has been spent for traveling, lodging during this time frame. All I know for a fact, because I represent the social workers that work under her, that, and they also went along with her on in this training into various counties within California. And I'm sort of mixing that, because that was a request for Debbie Jeter, and also number 7. So if you refer to number 7, it's saying that managers and workers were sent on a trip. So I didn't receive any information about number 4 or number 7 about the traveling, the lodging, and I also don't see in their response that the agency is disputing that this occurred, because they did in fact go to different counties.
You're saying, but they're saying they have no record of Debbie Jeter attending, on request number 4, they have no record of Debbie Jeter attending the training from September 2011 to September 2012. And then again, on request number 7, Pamela Tebow is saying, I do not believe the department has documents responsive to that particular request, although she wasn't quite sure what you were asking. So you know for a fact, number 1, that there are documents containing information as to how many days Debbie Jeter spent her training outside of San Francisco, and you know for a fact that there are documents as far disclosing how social workers and managers sent on trips.
Yeah, and I would assume that if you're a city official going on a trip on the city's dime, that there would be documentation to support that, receipts, and that's what we were requesting.
Thank you.
Member Sims?
I guess I have a question. So you said it was the ones that you found unresponsive were request number 4, as Member Nee kind of went through, right? And then what was the other one? Request number 7?
4, 5, 6, 7, and 8. Now, 1, 2, and 3, I do believe that they responded, but they aren't providing all of the information that we asked for. In number 1 and 2, for example, in number 2, the response is that I understand Labor Relations responded to this inquiry already, and they did not reply to everything that was being asked.
So you're saying, number 2 and number 3, where they say, where you're asking for as much information as possible regarding Louise Rennie, and they say,
and then, also when we asked for who was on an interview panel, how did someone get to the position that they're in, who else interviewed, the agency's unresponsive with that information.
Isn't,
I'm sorry.
I'm just wondering, I want to make sure that we're staying within our jurisdiction of what's sunshine and not collective bargaining agreement. So,
no. I totally agree. I'm just trying to determine what requests most likely the city has records for, or may have records for, and what those records could be, because I don't have Mr. Roher here to kind of ask him. So I got to kind of go on my understanding of what the requests for documents, and if they have any actual documents. A lot of these are beyond, I guess, requests for production of documents. They're more answer this question, they're more interrogatories. And they did respond on the December 17, 2012, as well as the October 12th?
They responded
2012.
October 12th, and then December 17th was only after I filed a complaint with Sunshine.
Yes. But there were some of the stuff they provided, I mean, at least when it comes to Sunshine, they provided detailed responses, which under Sunshine they didn't have to provide. They would only have to provide
Hold up,
documents.
guys. DC3?
I just wanted to clarify in response to one remark made. The request was made under two different authorities. One was the collective bargaining statute, but the other was the Sunshine Ordinance. And so, therefore, even if the material could fall under the collective bargaining statute, it would still have to be provided if required by the Sunshine Ordinance. So we're focused here today on the Sunshine Ordinance, so we can, I think, essentially put aside the issue of the collective bargaining. There might be provisions under the Sunshine Ordinance and the Public Records Act that exempt from disclosure certain personnel records. That's a possibility, but those are exemptions that come under the Public Records Act. That's all I wanted to add.
But I was going to say, I do agree regarding the unlikelihood of there not being some type of records if regarding travel. But, however, their claim is that Debbie Jeter did not travel during that time.
Yeah, and I represent social workers that traveled along with her.
Yes.
I'm sorry, I missed that.
I represent social workers that traveled with her. And I also wanted to point out request number 5. This is referring to the parking policy. I requested information, and in the second response, they refer to attachment 1, employee parking policy. But providing me with a parking policy doesn't answer the question as to who parks in the garage and how many people are from SEIU. It's just a policy, an agency policy, as well as a parking permit request.
DCA 3?
Yeah, and I'm sorry, I meant to say this before, so forgive me for interrupting again. The second point I was going to make is picking up on something referred to by Member Sims, is that, to the extent there are records that reflect these requests, then certainly they have to be provided. To the extent there are no such records, the department is not required to create them to respond to a request.
And that's kind of why I was trying to we may have to go detail of your request, because while they give you the parking policy, and that is probably the information regarding how parking in the garage at 170 Otis is decided. I don't know if they have how many people in the garage are from MEA and how many are from SEIU. I don't know if that record actually exists, that they could provide that.
I'm going to interrupt for a second. So what I'm reading here, Ms. Pabla, is your item number 5, if I'm parsing out what DCA 3 is saying, is really asking for 3 things. Information, how parking is decided, and then, bam, they gave you this policy. They printed out a policy for you. But then you had another question. How many people are in the garage are from MEA, and how many people are from SEIU? And DCA 3, am I inferring correctly that what you're saying is those records don't exist, so you can't, may or may not exist? I know I'm parsing this down.
Chair Fisher, I'm expressing no opinion about whether the documents exist. I'm merely saying if they do not exist, then the department is not required to create them to respond to the request.
Okay.
And I was going to say, the other issue is there is the issue of the response in September 26th, the response on October 12th in its timeliness, and then the, follow-up response on December 17th and its timeliness. So.
And timeliness, not untimeliness? Is that where you're going?
Well, I mean, they have to produce all the records within a certain amount of days, and if they're not producing it within a certain amount of days, and then later producing it due to a sunshine request, it's still a violation. But they might have produced the documents, but it's still not producing it in the timeliness that the sunshine ordinance requires.
Member Pilpel and...
Okay, so I'm starting to make a list in my head of issues with this one.
Oh, that's a scary place.
Sorry. So to Ms. Pabla, I guess the thing that most troubled me about the packet on page 301, your email of January 7th in the second paragraph, at the end of that where you said, given the difficulties that Ms. Tebow has in generating these documents, I might ask that we see a copy of Ms. Tebow's CV, her current position, job description, the process by which she got that position. One could read that as some kind of implied threat, and I don't know if that motivated their non-participation, but I'm just going to say I wasn't crazy about that sentence. Nevertheless, we still have stuff before us. So whether the original request was timely responded to is an issue. Whether sufficient documents were provided is an issue. And definitely their non-participation here in a 21E problem is there in a big way. So perhaps we could take a moment and just go through the 8 items. If you said that items 1, 2, and 3, you were...
There's some information provided, but not all of the information. And there's more information in the second request than there was in the first request.
Well, there was only one... Hold on. There was only one request that you mean response.
I mean, sorry, response. Yeah, there's more information in the December response than there is in the October response from the agency.
Understood. So taken together, is there still information in response to request number 1 that you think is out there that you haven't been provided, that is an existing document that's not asking them to go, create some new story or aggregate information from different sources?
So I feel like their answers are vague and not answering the question. They refer me to a website. They say they have no documents responsive to how many people applied for the position. And the questions that were asked in the interview, their response is that those are confidential. Not the answers, but the questions.
Right. And if, in fact, they have no responsive documents, and if, in fact, the information about panels and questions asked are confidential, then there are no further documents on that issue. Right?
Okay.
So, I'm just trying to get through these and see where there's a there. I heard what you said about item 5, and we're getting to that, and there may still be a thing there. As to item 2, Louise, it's not Louise Rennie, it's Louise Rainey, but anyway, did that answer your question about Ms. Rainey?
Let me just pull up their...
I think we actually need to go through
That's why
them,
I have to do that. My question was, is there value in going through all of these and Member Sims?
Well, I think there's value in going through them because I think I would rather go through them to figure out what may be more.
It was not rhetorical. It was a real question.
I just want to go through this once, and if there's a there, then there's a, and we may have some
that was
that
a
are
real
partial
question.
jobs.
And then we will hear from Member Washburn, who's been waiting patiently.
No, I'm fine.
She's fine. All right, carry on.
So in response number 2, I think that all the information is there.
Okay.
Response number 3, let me just...
Ms. Hilton?
So again, they refer me to a website, so DHR website, but that information was requested from them, and They didn't respond about how many others applied for the same position and who was on the interview panel.
And I think they made reference to request number 1 with the same answer, that they have no responsive documents and information about interview panels and questions are confidential. And I would infer from that that the number of, non-selected applicants is also not disclosed.
So I can,
May or may not have said that specifically, but that's my understanding.
yeah, I mean, I can assume that, but it's not stated. And also, the interview panel, who was on the interview panel, who was interviewing Ms. Hilton, that I don't see how and why that would be confidential, that who was on the panel.
We may not see how or why, but if it is, then it is. And I'm sure under not MMBA, but under the collective bargaining agreement or the city's employee-employer relations ordinance or some other applicable law, the Deputy City Attorney 3?
Through the chair, to the extent that there is an exemption due to confidentiality, the department is required to identify specifically the citation to the authority for that in their response.
Okay, so does someone want to make a note that for request number 1 and 3, there may have been insufficient justification for the withhold? Well, but if there's no document, then there's no document. If there's a document, then they need to either disclose it or explain why they're not. But if there are no documents responsive, then I don't know that they need to justify that there's no document responsive.
But that wasn't
that's
the
threshold
response.
question. What?
I think there wasn't a response. The response to the how many people applied for the position,
right?
They gave no documents. But when it came to information about interview panel questions asked in the interview,
okay, then there's probably insufficient justification there.
As well as,
at least on 1 and 3, there may be insufficient justification.
Identity of raters,
right?
Interview process, that kind of thing. They claim confidential in both of this. You say just like GCA3 said, like, there may be a justification, but they gotta identify it.
It's got to be more specific.
Yeah.
Okay. As to item, so we're done with 3. As to item 4, you did see Ms. Tito's email of January 11th in the packet at page 300, where she talks at some length about figuring out if Ms. Jeter attended training during that time frame, et cetera, et cetera. You did see that?
I don't, let me just look that up. What was the date of the email?
January 11th at 11 a.m., page 300. Yes. Does someone have the binder? Can someone? I know, I'm trying to
Oh,
get it to
yeah,
Ms.
I didn't receive that response, or because it was, I believe that was just directed to the Sunshine Ordinance, and I was not CC'd in that email, and I didn't see it.
Okay. Are you seeing it now?
No, I don't know where the binder is.
You're about to.
Oh, okay.
I would say it's entirely possible that Ms. Jeter attended training and did so on her own time. I have no idea. I don't know if she did or didn't, but this does suggest that they went through some level of due diligence to try to figure it out. And they're not here, so I don't know if this is enough, but this does have something on that point. Maybe you want to take a look at that and think about it. Yes, page 300. Oh, no. I don't know if it's that.
So I don't have the dates that the travel was, but I know it was some period between September 2011 and 2012, and I know that there were other members or city employees that went to other counties to see how other counties operate, so that because they were going through a reorg and Debbie wanted to reorganize the way that FCS, Family and Children Services, operates. So I see this response, but
I mean, another way to go at it would be to make a new request for anyone who traveled during that period and see what you capture there, but I'm not advising you about that. With regard to this, it seems like they appear to have done a diligent search in response to your item 4.
so so this implies that she did not travel at all in that year.
Or they didn't find anything that the city paid for her going away that time.
Hold up a sec. Member Pilpel. Member Washburn, you have a comment?
Yeah, sometimes we have cases where the city maintains that there are no records, that they can't find them. And so our recourse is to look at Section 67.29-7 about maintaining records in a professional way. So this person traveled, this person works for the city, did some traveling regarding her job. So it's reasonable to think that there might be records. So I think we would need to talk with them and say, why aren't there records of travel that really what happened?
I mean, having just got back from travel, and having been subpoenaed for my records for traveling, yeah, you have an expense report, you have flights, you have hotel, you have mileage. What I'm not getting on this is, I'm unclear as to whether they said she did travel and we don't have records, or she didn't travel and we don't have records, or we don't know and we don't have records.
I don't know, but I also wanted to point out that shortly after this, she announced her retirement, and unexpected retirement, and she's no longer with the agency.
Understood. And I don't know if she traveled or didn't. All I'm saying is this paragraph suggests that is a response and says that they did look. So, I'm not saying that they have or haven't or whatever. Is there anything further on 4?
No.
Okay, so on 5, I think I agree that you've got the parking policy, but the question about how many people in the garage are from MEA and how many people are from SEIU, even if they don't have a list as to what union they're in, I assume somebody's got a list for spaces 1 through whatever who's got parking privileges in that space, and at a minimum they could have given you that list, and if you didn't know which union they were with, somebody, you could have figured that out or whatever, but a list of who's got parking privileges in the garage seems fairly easy.
Yeah,
and I don't see that here.
Yeah, and A, they didn't indicate that those such lists exist, and B, they should have been here to provide that information if they couldn't provide it in writing.
Right, so I think there's something still there on 5.
And the employee policy was late. She didn't provide that until December 17th.
The whole thing, right. There were elements of it that probably weren't timely. On item 6, they say they have no documents responsive. Did you have anything further on 6?
They didn't respond to this. I have many members that can testify to Sophia instructing them to write down their job description because they were, without getting into a lot of the background, there's techs that do driving and transport children, and there was, the union actually requested a more clear policy on what they do. The agency clearly didn't have one to provide the union, and then a manager instructed some of the employees to start writing down what they do because management didn't know what they do throughout the course of their entire day because they are not supervised at one site. They're
all over the place.
Okay.
So,
I was going to say, but I think the question would be the quotation of Sophia is instructing some of her staff to write down their job description. Are there documents regarding either that statement and that action or communication with the Civil Service Commission regarding this? And There may be none.
Right. It may have been a verbal instruction.
It might have been, if it's a verbal instruction and it's somehow nothing regarding that was communicated to the Civil Service Commission.
Yeah, I don't think that the Civil Service Commission was involved at all.
And it may well be that DHR was involved, but not Civil Service, and if you make a request of DHR and find that there was something and HSA had it and didn't give it to you, then we may be in a different ballgame, but we don't know that right now.
Yeah, I doubt that, I don't think anyone was involved besides HSA management.
That suggests coordination, and I'm not sure that they, so on item, so I don't know that there's anything further on 6. On 7, this, I'm not quite sure what you're asking.
So managers and social workers went on trips to other counties, and they were trying to see which county has a better procedure of policies and how they handle their clients. And they were instructed to choose one structure that they liked the best of all of these different counties, but they were not allowed to choose San Francisco, meaning that San Francisco didn't work, the way that it operated didn't work, and we wanted to know the rationale to not include the way that San Francisco operates with family and children's services.
And you think that there was an email or a memo that asked them to do this and not a verbal request? Or you don't know?
No, I don't know. I think that these were actually committee meetings, so I think it was a verbal request.
So are you requesting documentation about this? Because I've actually done this. I have done this in management groups. Pick something that is not ours. Tell us what you want. So you're coming at, I just want to make sure you're not coming at this from everything's against me. And maybe there really is a solid rationale for this. Maybe there isn't. I just want to know, all I care about are the documents. Were you not given documents for this?
Yeah, so we were given no documents, but this is a regular working committee. And to come to the conclusion that, Contra Costa County does it the right way, so we're going to now follow their model or what have you, there should be documents, committee meetings, minutes, providing that what this group did for several months when they traveled to different counties. And many of the people that traveled were our members. So I was asking for documentation, and they didn't provide any.
If you do a follow-up request and are more specific, if you know the title or the general concept, if you can say the FCS restructuring working group or the blah, blah, blah committee, if there are any notes of that meeting or where the question of structure or restructuring was discussed, that's what you're looking for. That might help because it may well be that the way this is written, they couldn't interpret it in the way that we're now discussing it. I don't know.
Perhaps, but I mentioned social workers, and the social workers are only in FCS. And also, I wanted to point out in the response, the second response, the response changed from the agency has no documents responsive to this request to I do not believe the department has documents responsive to this request.
Well, the first response was in the MMBA context, and the other was in the Sunshine context. So.
But it should have been in both contexts because the request was made in both.
Yeah. Okay. I mean, I'm not saying that, I don't think we're saying that they did a perfect job on any of this. We're just trying to figure out where there's still stuff that you're looking for. And then as to item 8, they provided some stuff in attachment 2.
Well, I actually want to go back to number 7 because that alludes to that there may be documents that exist that are responsive to the request. When you're saying, I do not believe, she's not absolutely positively saying the agency has no documents. Her response has changed, and in fact, it's less conclusive than the first response.
So we can ask them to do a more diligent search based on the discussion that we just had about what you were actually looking for. Okay, that's cool. And then for item 8, they had some stuff, the email from Mr. Cunir, and a couple of examples of checking out laptops and things. Is that not sufficient?
Yeah, this actually doesn't tell
You
us.
wanted a list?
Yeah, we wanted a list of who has what, when, how, because there isn't a policy or anything that was given to us at this time. Now, we have met with management in a different forum in labor management meetings, and we have received some of this information a month ago, but that does not comply with the request of information from September. So it's still a violation.
Fair enough. And is that list or information that you got as a result of those meetings sufficient to address this, or did you want a more
No, yeah, we have all the
list?
information for number 8, but
But it still wasn't provided, nor on a timely
Yeah.
basis, et cetera?
Yeah.
Okay. All right. I'm good with that. It seems like there are bucket load of potential violations here, so we would need to just write that up. That's where I am.
Madam Chair.
Member Nee?
Yeah, revisiting item, request number 1 very briefly in the response there too. The respondent states, information about interview panels and questions asked during an interview are confidential. I am not so sure that information about interview panels is confidential. I just looked at the list of exemptions under Section 6254 of the California Public Records Act, and I saw no such exemption on that. There is an exemption in 6254G. It says test questions, scoring keys, and other examination data used to administer a licensing examination, examination for employment, or academic examination. So that information is exempt. Even having said that, however, I will add that the respondent failed to note that particular provision in its in their response, and that's a violation of Sunshine 67.27. And I do not, as far as information about interview panels and questions asked, I don't see those listed under the Sunshine Ordinance anywhere, but again, there is no, particularly on the question of information about interview panels, that is not specifically exempted that I saw in 625 in CPRA 6254. If somebody else has better information on that than I do, by all means. But I just didn't see it.
Mr. Threet, you have something to add?
Sure. I spoke previously about the need in the ordinance to cite the specific authority. In terms of whether there actually is a specific exemption, I don't know, but there are, because I haven't tried to search for one, and it's their obligation to provide the citation. But the Public Records Act includes something that is kind of a catch-all provision that pulls in other exemptions that may exist in other statutes. So the fact that there's not a specific exemption in the Public Records Act doesn't mean that there's not an exemption that exists in some other statute. That's all I would say about that.
Under MMBA? No. EERO? I don't know. Anyway, yeah, I get you.
Well, normally, do I have any other comments from the task force? Because normally I would ask each side to give their rebuttal.
I do have one comment. I just wanted...
It's all yours.
Thanks. I just wanted to add that the agency has an entire department devoted to labor relations, and one of their labor relations analyst or personnel analyst or someone from personnel could have been here today, but they chose not to be here in person to answer these questions.
Do I have any motions on the floor?
Well, one motion I definitely want to find, I would like to find them in violation of 21A.
21E? E, Edward? Okay.
Yes, not sending a knowledgeable representative. And I think that, I think other people can deal with the The other issues that are before us, but 21A to me is glaring, and I think it's offensive, to be honest, that someone from HSA doesn't show up.
Members to my right? Oh,
I'll-
wait a second on that, yeah.
I was going to second a large motion that includes all of the
Yeah, I want to see if anybody
the
wants to
list of
pile
stuff
on
that we
that.
put together here. That's fine. So I'll second.
I will withdraw my motion to allow for a broader, more comprehensive motion.
Which I'm happy to second.
Well, so we don't do motion by committee here.
Yeah.
Do you have the whole list? Because I'm looking at Member Washburn, who I think probably can just rattle them all off for us.
No,
Or
Member
Nee.
Nee. Member Nee can do it.
Let's,
But I think one of the newer members should take a crack at it. You've hit all the
I
points.
say let's be efficient.
Member Nee.
yes, because we'll have to go to public comment, and that could take forever.
Madam Chair, since I am being recognized, I move
Thank
to
you.
find violations of the following sections: 67.21B, for uh, 67.21B, for failing to justify withholding by demonstrating that the record in question is exempt under express provisions of the Sunshine Ordinance. 67.21C, for failing to assist the requester in identifying the existence, form, and nature of some of the requested records. All right, withdraw 6721C.
So you have B and E so far?
B and E. 67.26 for failing to keep withholding.
Excuse me.
Oh, hello, yes, I'm sorry. DCA 3, yes.
I'm just, going down the list and reading along with you, I don't see a requirement that they be requested to do so. The request to do so applies to the providing and writing within 7 days following a request, a statement as to the existence of these documents.
Okay, so, Mr. Threet, you are suggesting 67.21C does not apply?
No, I'm suggesting that C applies and that they're required to assist a requester of public information regardless of whether that requester said, please assist me.
Okay.
So we'll put C back in.
We'll put C back in.
Can we discuss that for just a quick
We
second?
can put it back in and request a separation. That's, in the interest of time, that's my suggestion.
All right, I'll comment on that in a moment.
Okay. 67.26 for failing to keep withholding at a minimum. 67.27 for failing to cite the specific provisions under which certain records are being withheld. So specific statutory provisions under which certain records are being withheld. Last but not least, Section 67.29-7 for failure to maintain correspondence and records in a professional and businesslike manner.
DCA 3?
I'm just I have no opinion on the last part of the motion, but I just want to point out that the finding of a violation of 67.27, I'm sorry,
29-7.
29-7 presumes that the records did exist and were not preserved and kept in an orderly manner.
Well, that, I think under the discussion that's transpired over the past 45 minutes or so, I think that has been, I think that has been pretty well established. You know, when they talk about travel records not kept and other things like that, I think a case can be made for that.
Member Nee, will you also please add 21E to your list?
Did I not say 21E?
No,
did you?
I wrote it down.
Oh, I apologize. I thought.
I'm not sure I did, and
I'll reread them.
21E, 67.21E for failure to send a knowledgeable representative to this meeting, to this hearing.
So we've got B, 21B, C, and E.
67.21B, 67.21C, 67.21E, 67.26, 67.27, and 67.29-7.
Member David?
So in the interest of efficiency, I think that if there's anything that needs to be separated from that to be discussed, I would like to ask Member Pilpel if there's, one or two that he would like to, then can we vote on the remaining?
I think we should have a second first.
Yeah. I'm sorry? Oh, I will second. I apologize.
Thank you.
Yes. Yeah.
Okay.
I will second. But I was wondering, can we find out which ones people are going to have an issue with, separate them out, and then vote on the remaining as a block, and then discuss the individual ones?
I'm absolutely with that. The only two that I take any issue with is 21C. I don't want to read that an EFNQ request is implied in every public record request made. I think that you make a specific request for a statement as to the existence, form, nature, and quantity of records, and that there is a general requirement that departments assist requesters in finding information that's both in 21C and a separate section that I'm forgetting right this second. But I'm not sure that I would agree that there's a violation there, nor do I have evidence that 67.29-7 was violated here. It does appear that they've got records just because they say that we don't have any record. I don't think there's any evidence before us that says that their records are in disarray and are not maintained in a business-like fashion. I think that they have failed to provide certain records and failed to justify in certain ways and failed to show up. So I'm with 21B, 21E, 26, and 27. I'm absolutely with those. I'm just not with you on the other two pieces. So if you're willing to take those out, then I'm happy to support the thing as is. Otherwise, we'll just divide the question and vote on those separately.
Well, I think we should divide the question.
Okay, that's cool. So then I would ask that we divide out 21C and 29-7, have one motion for those two and the other motion for the other four sections. And I'm happy to go with that course of action.
I'm fine with that.
Okay.
The seconders fine with that also.
So now we have two motions, one with all of them, and then the second one just with
No.
No.
One with...
Well, I didn't finish my sentence. Sorry. One with all of them, minus 67.21C and minus 67.29-7, and then the second motion has those.
That's correct.
It was a longer sentence.
Okay, thanks.
Do you want to just bang two of them out at once? No, let's do them separately.
Why don't you...
I'm getting there.
Yeah.
Seeing that there is no members of the public who have not offered facts and evidence for either side, there is no public comment. Unless there's somebody behind the podium that I can't see.
There is nobody in the
Nobody
public
in the
section
gallery.
who is not a party in interest to this case.
That is a better way of stating it. So, let's go with the, Madam Clerk, can we take a vote for the first motion, please?
Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
And this is on the 4, the main 4? Yes.
Pilpel, aye. Member Sims?
Aye.
Sims, aye. Member David?
Aye.
David, aye. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Member Oka, aye. And Chair Fisher?
Aye.
Fisher, aye. You have 8 ayes.
So can I, so the motion passes. I'm probably going to send these both to the same place. Can I just, let's vote on the other one.
Member, on the second motion, Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
No.
Pilpel, no. Member Sims?
Aye.
Sims, aye. Member David?
No.
David, no. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. And Chair Fisher?
Aye.
Chair Fisher, aye. 6 ayes, 2 noes.
I'm going to ask Member Washburn, I'm going to recommend this go to compliance amendments. I have a feeling it's going to end up back here in front of all of us, which I don't think is such a bad thing, because I would actually like to hear the other side of this, but it's your committee.
Well, no, the way it works is it comes to compliance and amendments, and we get an update on what's going on. And sometimes, once in a while...
I'd be happy if everything got solved.
Yes, that sometimes happens, but not always. And in that case, then we send it back here for, we sometimes recommend that it go to ethics. You know, we have our strong feeling that that's where it needs to go, even though nothing will happen. Or we think it might better go to EOT. Or they have another chance at providing the document. So let's, compliance and amendments is the logical place for it to go.
Okay. So noted. Sorry, I'm just catching up to where I am here. So that concludes that item. And we continued items 6 and 7. And seeing no public comment, I guess that item is closed then, right, Madam Clerk? There's nothing else I have to...
Thank you, Ms. Pavlik.
Thank you. Come on up.
I'm unfamiliar with the process, so you said it goes to compliance and amendments. What does that mean?
I'm going to let the chair of the committee speak.
So there will be an order of determination issued that will summarize what happened here and will cite the violations. And the department will have, I think, 5 days after they get this sort of determination to supply the documents. And if that happens, then great. But it'll be calendared for compliance and amendments to see if they've complied. And it'll be another hearing like this.
Okay.
And if they don't come to that one, they're in really big trouble.
Okay. Will I be notified of that hearing?
Oh, yeah, absolutely.
Compliance amendment will be on the 18th, June 18th.
Okay.
That's a Tuesday.
We may not, and the order of determination may not be ready by then, in which case it would come in July.
Okay. And can I make a comment? Oh, I just wanted to add that I'm one person that represents 1,600 members, and labor relations within HSA and personnel is a huge department with a couple hundred employees, and they definitely could have and should have been here today. Thank you.
Okay, item 8.
Item number 8, motion to communicate to the appropriate state government officials the task force's opposition to proposals in the state draft budget for fiscal year 2013 through 2014.
Member Nee, would you like to lead the discussion?
Well, yeah, it's unfortunate that the copy of the information packet does not contain the actual motion that I had sent to the chair. But let me take a crack at it, and we can go from there. I move to communicate to appropriate state government officials the task force's opposition to proposals in the state's draft budget for fiscal year 2013-2014 to 1, impose fees for access to court records, and 2, halt state reimbursements to local governments for expenses incurred in complying with state public records laws, and B, to inform local news media of said communications. Let me further stipulate that by appropriate state government officials, the list includes but is not necessarily limited to the following: the governor, the chairs of the Senate and Assembly, Judiciary, and Budget Committees, and San Francisco's representatives in the Senate and the Assembly.
So that'd be Senator Leno and Assemblymember Amiano.
Senator Leno's Senators Leno, that's Leno and Yee, and Assembly members Amiano and
Ting.
Ting. That's correct. I will note that Senator Leno also chairs the Senate Budget Committee, so that kind of kills two birds with one stone.
So we have a second. Does anyone have any? I mean, I'm pretty familiar with this. I actually spent a lot of time reading about this. On my left, does anybody have any questions about that? Of course, Member Pilpel.
So just to start with, this just seemed really weird and random. In our packet, page 449 and 450, was this thing just randomly tossed in here and not on topic? There's a two-page memo about the police department's alcohol beverage control liaison.
I did not include that information in. That was slipped in by somebody else.
Jerry, can you wait for one sec? Because I have a more substantive question. So we don't know anything about this.
I know nothing. Perhaps our administrator
Page
could enlighten us.
449 and 450.
449?
If it has to do with alcohol and beverage, it's probably in there just randomly. It should not be in there.
Okay, got it. So I just handed out the sections from the admin code about the State Legislation Committee. I continue to be concerned about whether or not we can appropriately make this communication. I am generally of the view that we have jurisdiction over petitions, alleged violations of the ordinance, that we advise the mayor and the board and department heads, et cetera, but that communicating with state government officials about position on the state budget and legislation is not generally within our purview. So DCA 3, can you advise about whether this motion, in your view, is in order and whether the task force has the power to make this decision and to communicate in the way proposed?
I have advised Member Nee that is appropriate, and since I wasn't aware that you were going to request this information, I'm not prepared to give you the specific site, so perhaps you could move along and discuss the matter, and I'll get them to you in time.
Okay. I'm waiting.
And,
That's cool.
I have to say, Member
Because I asked
Pilpel,
about this at last month's meeting and was told that we would put it off and that we would, find that we had authority to do so. So that's why I was looking for something more specific, and all we got in the packet was the same material.
well, what I heard Mr. Threet say, and you can clarify this, is that this is perfectly kosher for Member Nee to.
What I said is that I believe it is appropriate, but I'm going to spend some time to find some provisions of the ordinance which I looked at that I believe would cover this situation.
Okay.
And as a general matter, it is appropriate for any city policy body to express its opinion on legislation to the legislature. It's the opinion of that policy body. It's not the city's position. It's the opinion of that policy body.
And I'll get you to settle.
Okay. With due respect, though, that's not what the admin code provides. Very specifically, as I just handed out, Section 5.5, any proposal, I don't have to read it here, that...
Member Pilpel, perhaps you could give me a copy of that.
I gave Task Force Administrator...
Madam Chair?
Yes, Member Nee.
Yes. The sections that Member Pilpel, the administrative code sections that Mr. Pilpel is referring to, refers to A, consideration of pending state legislation, Section 5.5, Section 5.6, duty to study proposals and make recommendations. It shall be the duty of the State Legislation Committee to study all proposals enumerated in the preceding section and to formulate recommendations for endorsement, opposition, or neutrality with respect thereto. That assumes that a State Legislation Committee has been created, and indeed the State Legislation Committee would have that duty. However, there is no proscription anywhere that I have found that would bar us from publicly expressing our opinion on this.
Well, and also the 5.6, it says it's only their duty to study the proposals and make recommendations regarding endorsement and make it as a matter of policy to the city and county, not of certain commissions or the Board of Supervisors. And then even 5.11 says the Board of Supervisors can say damn with whatever the legislative committee says. They have no power to abide or to even consult them. So I don't see why we would have any power or need to abide or consult or anything else.
So I'm going to hold off. I'm going to go first, and then I'm going to ask Member Washburn. Member Pilpel, I respect and admire your enthusiasm and what you do for this committee, and I'm so happy to be sitting next to you at most of these meetings. In this case, however, I'm going to recommend that we go with Member Nee's motion and proposal because, this isn't about, gay marriage or, which is fine, but gay marriage or keeping the bars open. This is our bread and butter. This is, let me finish. Our role here on the Sunshine Ordinance is to lessen the burden on the populace and make sure that they get their rights and they have access to documents. And now I read something like this that is basically saying to people, oh, now you're going to have a financial burden. And, as long as Mr. Threet says, we as a body are entitled to say this, as long as we're not doing something, really out of process or even out of the law, I'm going to recommend that we go with this. And then Member Washburn was next.
Right.
And then you may respond to both of us.
Okay, this State Legislation Committee would be a committee that would recommend something that the city and county as a body would support, okay? That's not us. We're not, when we support a piece of legislation, it's as the Sunshine Ordinance Task Force, not the city and county. So this doesn't apply to us. This is irrelevant. And also, several times in the past, since I've been on the task force, we have supported legislation. Senator Leno's has brought a couple of matters to us in the recent past, and we...
Were they related to sunshine?
Related to sunshine,
Because
specifically.
while I would love to support gay marriage and keeping bars open till 4 in the morning, I really want...
No, this is, you're right. I agree with you completely. It's in our purview. We're not speaking for the city and county. We're not committing the city and county to anything or sticking our neck out.
Member Pilpel, would you like to respond?
Yeah, just very briefly, I don't think the state proposals are a good idea. I think they should be opposed. My concern is that the intent of those sections is that the city speak as one voice, so that it's not that this body thinks that, SB 102 is a great idea and the PUC thinks otherwise and Rec Park has some other comments about it. It's that the city speaks as one voice, does that either through the State Legislation Committee or through the Board of Supervisors, and that other bodies of the city are not authorized to take positions on state legislation that haven't been approved by one of those two bodies. It's so
Fine, let them sue us.
Okay, well, I'm just saying, and it may well be that this motion passes and you communicate however you communicate. I just don't think that we have the power, and and that's it. I wouldn't
Isn't this
want...
more of a recommendation? I mean, we're not slamming our fist on the table.
It's taking a position, and I think that the city has a different process for how that works, and I don't think that any appointed body in the city takes positions on legislation in this way that haven't gone through this committee or the Board of Soups. That's why there's a process set up for it. It's in the admin code, just as the Sunshine Ordinance is set up in the admin code.
Hold on. I mean, I think the day that the city is united as one is the same day pigs are going to fly across that window there. But Mr. Oka, you have something?
I want to point out, as Member Nee has said, and I think we all know, that this is not coming from the city and county of San Francisco. This is coming from us as a task force. And I think we as a body have the right to express our opposition to this specific provision of what's being proposed by the state hierarchy, or however you want to put it. This is not binding the city to anything. It is our opinion and our opposition to this thing that's happening that shouldn't be happening. So I think we don't have anything. And if we do, like Member Nee said, let them sue us. I agree.
And I appreciate you. I mean, this is, from what I've heard about other motions, this one's pretty benign. That isn't going to set us up to be sued. So, I mean, if you were going to come and make some crazy motion about forcing the supervisors to embrace God, mother, and country, I might have a problem with this, but I'm okay with it. I agree with you on this one.
Madam Chair?
Maybe we could copy this to the Board of Soups and the committee, and then I'd feel a little better.
It'll be a matter of public record. Madam Chair?
Yeah,
couple of things. Let me just repeat the appropriate state government officials I listed: the governor, the chairs of the Senate and Assembly Budget and Judiciary Committees, and San Francisco's representatives in the State Senate and Assembly, and ask colleagues, are there any other legislators who you believe should be added to that list? Okay, hearing none. One other thing. I think the letter can include an explanatory statement of what the task force is, how, why we exist and what we do.
Member Ney, I'm wondering, is it appropriate, should we include
Jerry has a question.
Lieutenant Governor Newsom and, Secretary of State in the list of people that we're sending this to also?
No reason why not.
Well,
I'm sorry, say again?
I would rather keep it, when you start doing the whole and you see, then you want to put Betty Yee, Board of Equalization, and then the Controller and the Insurance Commission. I almost think it dilutes it. Let's focus it on the
It
people.
doesn't matter. That was just, it's fine either way.
Mr. Threet, you had a comment?
Yes. With regard to the San Francisco Administrative Code provisions, Section 5.5 et sequata, I don't think that these provisions restrict what the task force can do. It's an affirmative grant of authority to this body to consider and state the official position of this city to the appropriate folks in the legislature. That doesn't necessarily preclude any other body from expressing the opinion of that body. And if this ordinance did so, then it would be incumbent on the Board of Supervisors not to pass resolutions supporting and opposing different legislation that goes through the legislature. There are a number of policy bodies, including the Board of Supervisors, who take positions on things that are moving through the legislature. And there also is an official lobbyist of the city that is given direction as to the official position of the city and lobbies legislators from that perspective. So they get a lot of input from a lot of different sources, and a lot of it comes from within the city and county. With regard to the ordinance itself, there's no specific authority in the ordinance that would say that the task force can do this, and similarly there's no specific authority that says you cannot, but there are multiple provisions that suggest that this type of action would be appropriate. In 67.17 of the ordinance, it specifies that the free speech rights of members of policy bodies remain intact even though they serve on those policy bodies, and they may express opinions on legislation that's moving through the state legislature and the Board of Supervisors. 67.30C is a general discussion of the authority of, excuse me just a moment, of the task force. And one of the things it says there is that they advise the Board of Supervisors and provide information to other city departments on appropriate ways to implement this chapter. Now, granted, that's within the city and county of San Francisco, but the Board of Supervisors is the one that passes that policy. There's also 67.32, where it says that the task force is charged with advocating for open government with other entities for which the ordinance does not apply. So I think if you read those provisions, and consistent with the lack of prohibition on this, that it's something that the task force is permitted to do but not required to do.
Yeah, and again, I'm really thankful to the people on my right that come from the newspaper, the League of Women Voters, the journalists that watch out for this stuff, because I missed it, just as I'm thankful for the encyclopedia here of all city policy and state policy on my left that keeps us honest. So, I kind of want to at least recognize and acknowledge that.
That's the geographical right and left you're referring to, right?
Now, I would not have known about this if you hadn't brought, yes. Oh,
Very good.
I didn't even catch that one
You all get up and look around.
on my
If you keep going to the left.
geographic left. So I actually appreciate you bringing this, and this is our bread and butter. This is what we do. Let's take a vote. The motion is that this is a letter, right?
Yes, communicate to the appropriate state government officials the task force's opposition Two proposals in the state's draft budget for fiscal year 2013-14 to, one, impose fees for access to court records, and two, halt state reimbursements to local governments for expenses incurred in complying with state public records laws, and B, to inform local news media of said communications.
One quick question.
Yes.
Have you heard from any other cities, bodies, task force? I mean, are other people up in arms about this, or are we the pioneers on this? And then we'll go to a vote.
Well, there are, within City Hall and within other jurisdictions, I have not seen or heard anything. On the other hand, there are a number of advocacy organizations that are very interested in this, including Californians Aware and the First Amendment Coalition.
Okay. So this needs 6 to pass, right? Can we get a roll call vote?
Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Pilpel?
No.
Pilpel, no. Member Sims?
Aye.
Sims, aye. Member David?
Aye.
David, aye. Member Highland?
Aye.
Highland, aye. Member Oka?
Aye.
Oka, aye. And Chair Fisher?
Aye.
7 ayes, 1 no.
So,
Okay.
Chair Fisher, I would suggest that Member Nee drafts the letter. DCA 3 should review it, and either you or Chair Grant should sign it. And this probably needs to happen.
I have already drafted the letter, actually, and submitted copies thereof through the administrator. However, I will be glad to redo it. I actually need to draft a couple of other letters to the judiciary committees, and also I'll be happy to draft the press release, since it's a somewhat journalistic endeavor there.
And copies of all this stuff to members of the task force. Thank you.
Well, I will send, through the administrator.
The final, that's all.
Through the administrator, I will do this. However, I should point out that, there is a timeline on this. I'm
not asking that we delay it. I'm just saying once it's
the budget,
that we see it.
The budget
It's coming up soon.
theoretically is to be adopted at the end of this fiscal year, which means in 26 days from now. So, but I will resubmit everything and do it forthwith.
Okay.
And we should note that there was no public comment on this matter.
Oh, seeing no one in the gallery, there is no public comment. Public comment never opened, so it's not closed. Item 9.
Item number 9, approval of minutes, January 16th, 2013 special meeting.
Madam Chair.
Yes.
I'm going to move that items 9 through 13 be continued. And there is a reason for it. There is a major element that is missing from all of those sets of minutes, and that is timelines of the individual items within those minutes. This is especially important since we have gone from detailed minutes to action minutes. When people are looking, when members of the public are looking at our minutes, and they just see a very brief summation of what happened, and maybe there's one or two items that are going to really pop out at them, and they're going to want to go and listen to the recording of our meeting and find out what happened on those particular items. And it's important that they be able to know where, time-wise, during the meeting that occurred. This was initially done, and it hasn't been done in a while. I would like to see that practice re-implemented, and so that is why I'm moving for continuation on items 9 through 13.
Do I have a second?
Second.
Discussion?
So we've had times and not had times. We adopted minutes over the last couple of months that didn't have, some of which had time, some of which didn't, so it's inconsistent. I don't know that I believe that it's not required. It may be helpful to some. I don't have a strong view one way or the other. I had already made a set of edits to at least the first set of minutes, and I had a question on the substance, if I can get some clarification on that. But I'm certainly happy to continue items 10 through 13. And if you're concerned about times, I think we need to figure out who's going to figure out those times to add to the minutes, if that's something that, you know, you want to take on, or if that's something that you want to have one of us take on or have the administrator take on. Either way, it's a task. But with regard to the substance, on the January 16th minutes on page 2, members Nee and Washburn, if you could clarify for me on item 3, because this is a meeting that I was not at. The language of the motion on item 3 is a little vague. Could you help me with the wording there? It says move to find page 2 of the January 16th minutes, item 3. Member Nee, seconded by Member Washburn, moves to find violation of Sunshine Ordinance Section 67.26 for failure to keep withholding to a minimum for unauthorized request of redactions, Arts Commission to provide documents unredacted. It's just not reading well, and I'm trying to have it make a little more sense. At least I've got at the end, Arts Commission to provide unredacted documents, but I'm having trouble with the withholding to a minimum for unauthorized request of redactions. Can you make that read better somehow?
Or should we just continue that?
I would have to go back and review it. I think I could probably do something off the top of my head, but I really think it's best that that be reviewed. Thank you for bringing it to our attention.
Okay, so if the two of you can look at that, then why don't I hand in my edits for the rest of it, and we're going to continue these anyway, so we'll get a better version of that for next month.
In terms of your previous question as to who should do this, I realize that our administrator already has her hands more than full, but you know, I would like to see our administrator tackle this, and it doesn't have to be done all at once. You know, we could do like 1 or 2 sets of minutes, maybe 2 sets of minutes over each of the next several meetings, and that would take care of it, I think. You know, we don't have to get this done all at once, all in 1 month. You know,
would it be possible? I don't know if this is even legal, for lack of a better word, but I'm all about being proactive. But if nobody ever, or if only one person requests it on a specific, like the April something minutes, could we just do that one? Do it on a as-needed basis? Yes, but you're looking at me like
Well, the minutes are posted on our website, so members of the public can go and see them. So,
Well, if somebody wants to, so is the issue here that I've read the minutes on the website and I go, whoa, wait a minute, what does this mean? Okay, now I want to listen to it, and I got to sit through 4 hours? Are you saying that you want timestamps? Like items 1 through 2 went from 002 to blah, blah, blah.
Yes, and I believe, as a matter of fact, that when we first went from detailed minutes to action minutes, we brought that matter to Clerk Angela Calvillo, and she agreed that it was good practice. And I think she instructed our previous administrator, Mr. Rustum, to do just that. And it's regrettable. I agree. This is something that should have been brought up a long time before. And I'm, since I'm a knowledgeable person, since I'm a person here with institutional knowledge and memory, really this falls a good deal on my shoulders.
Well, I
still think that it needs to be done.
So I'm just going to look forward, because that's what I do. Maybe we could do although I have to bring this up with Chair Grant. I'm not the chair anymore after tonight. Maybe we could, as we move forward, as we go from item 2 to item 3 to item 4, we could do a verbal timestamp or something. It is now 5:27, and then Ms. Osbury would capture that in the minutes.
It's not the...
No, it's not the real time.
Well, no, but you have a running...
It's not the real... It's like...
No, I know where you're going on this. We have these little things at work, and it counts. It does this automatically, and it counts like what time stamp it is.
I also think we should give Ms. Osbury a chance to address us on this if she wishes.
Yes.
Ms. Osbury?
Yes.
Before she shoots all of us, metaphorically?
I appreciate Member Nee stating the fact that I am a body staff of one for this. And moving forward, I would suggest definitely doing a counter. Since you've had minutes prior where they didn't have the counter, that wasn't the issue. Because you're talking about several minutes on this agenda, whereas you know how long the meetings are. That means me sitting there listening to that, and I don't have the time. So my suggestion is moving forward to have a counter on there. Otherwise, you're talking about 8 hours, or at least 5 or 6 hours per each item going back and listening to a counter. It's listening to a whole meeting.
I mean, you just go to whatever it's called, DTIS, and say, we need something, we need a recording with a counter, and it click, click, click. I mean, I've used those before. It starts at 0, so it's not, 5:30, it's 0, and then it counts. But you do have to, you do have to speak into it and say, item 2, item 4, item... Where are we? I have a motion, don't I? We have discussion.
Motion is continue items 9
Yes.
through 13.
So we have completed.
Public comment?
Seeing as there is no one in the gallery, there is no public comment, can we pass without objection? Okay, the matter of continuing items 9 through 13, I'm talking slowly for Ms. Osbury, 9 through 13 has been continued to next month. Item number 14, Compliance and Amendments Committee. Alice, Member Washburn.
Okay, well, the meeting was canceled in May because we really didn't have any matters to discuss, and I was trying to remember April and was coming up blank. But,
well, you got 2 coming at you this month.
Well, I just looked at the draft minutes, and we had 2 orders of determination to hear, and nobody showed up. We passed some minutes. And that was about it. It was a very short meeting.
Thank you. Oh, really?
It isn't always like that.
Public comment, seeing as there's none. Okay, thank you. Item number 15.
Report Education Outreach Training Committee.
Member Pilpel, can you give us a brief?
Yes, we met twice, April 29th and May 13th, heard 5 different items over the course of those meetings, and thank you to the other 3 members who were present at both of those meetings. We did refer the Library Users Association versus Supervisor Campos item back to the full task force, and I also am not clear on why that wasn't here tonight. There was a lot of concern at that meeting about Supervisor Campos not being present. There was a response.
I can answer that if you want.
Oh, okay.
Because until, I don't know, a day or 2 ago, we already had 5 items, and I was worried that it was going to be too full. So Chair Grant, when she handed this over to me, said,
what do you want? Okay.
let's, was it first in, first out kind of thing?
Could we try to have that before the full task force next month?
It's going to be next month.
Okay.
Yeah.
Because I think we really wanted to resolve it one way or another. Either there was some communication back from Supervisor Campos, that should be in the packet. Either that's good enough and we're done with it, or it's not good enough and we need to do something else. But either way, we wanted to.
It was just time.
Okay, that's fine. That's cool.
Bucket was this big, we had this many.
Yep.
Yeah.
And we are intending to meet possibly the 17th, but that now may get moved, so we could meet so as to accommodate Member Highland the 24th, 25th, July 1st, 2nd, 8th, or 9th. So maybe once, hopefully twice in that time frame, maybe spaced out. If I have anything to do with it, it'll be pretty spaced out because I'm kind of... that's it. We're doing what we can with the OT and trying to get through our backlog, and thank you.
Okay, no public comment, so item 16.
Item 16, Administrator's Report. In front of you, I've handed out the Administrator's Report. I won't go through it in detail. It's pretty much detailed on the cover sheet. There have been quite a bit of mediations, but without success, maybe 1 or 2, and there are 15 complaints currently in the pipeline.
15?
Yes.
Ooh, we got to get moving.
So on that, Madam Chair?
Actually, I have a question for Madam Clerk. So on your memorandum on number 4, mediation of complaints, those are, so I'm reading this right, all those bullets are the ones you are mediating?
Have been.
Have been. Oh, okay. So, for example, 13017, unresolved, request for hearing, that means there's going to be hearings. That's...
It means the hearing is coming up, is pending.
Uh-huh. Okay. Oh, wow. Okay. All right, I'm done. Did you have something?
Yeah, so I'm just trying to clarify. The complaints in pipeline 15, does that include the complaints of anonymous that are on hold, or does it exclude those?
Excludes.
Okay, if we included those, how many of those are there that are in that limbo state?
Off the top of my head, I can't tell you.
Okay.
She had quite a bit that she had submitted. But her issue and what her request was is that they not be scheduled or heard until further notice from her.
Okay.
We don't have a date.
I guess I'm concerned about a couple of things. One is whether or not a complainant can just put something off indefinitely, and whether the complainant is controlling the scheduling in that way of our workload. And the second is, if we really do continue to have at least 15 live complaints before us, if the current pace of what we're trying to do is sufficient, or if we need to look to schedule a couple of special meetings over the next few months to make this backlog go away. Because we're still seeing things that were filed in 2012, and here we are halfway through 2013, and that's not 45 days. That's not good. It's just not good. And I know it means more work on our part in the near term, but I don't know how better I don't know what we can do to get at that backlog, and I don't like having that kind of a backlog here. So I'm just putting that out there. It's bugging me. Thanks.
Yeah, I didn't know it was 15, but... All right. Where are we? Okay. I'm sorry, Madam Clerk, anything else?
No, that's it.
Okay, so now the one we've all been waiting for, announcements, comments, questions, future agenda items. The first one I have is, and then you'll go second, is what we're going to do about the July meeting. What was yours, Member Nee?
Well,
If you have an announcement, let's go with that
I had
first.
an announcement.
Go with the announcement, it's easier.
Well, okay. There are a couple of bills moving through the legislature very nicely. These are political transparency bills. Number one is Senate Bill 52. This is authored by Senators Leno and Hill, and it would require that campaign advertisements and websites reveal their top sources of funding. That has cleared the Senate, and I believe last I knew was awaiting a committee assignment in the Assembly. The other is Assembly Bill 400. This is authored by Paul Fong, and that would require that circulators of ballot petitions have on hand and available for public view their lists of top funders. That has passed the Assembly, passed the Senate Elections and Constitutional Amendments Committee, and I think it's now before the Appropriations Committee. Those bills can be tracked at leginfo, leginfo.ca.gov.
Okay, thank you. So then, does anybody else have any announcements before we get into the rescheduling of the meeting? Anybody over here? No? Okay. Madam Clerk, I think this was a chicken and egg problem. We couldn't schedule our meeting until we knew it was available.
Yes, so I found out that hearing room 406, which is right next door to us, is available on July 9th. And for, starting at a 5:30 time, though.
July 9th is a, sorry, a 2,
Not available earlier.
there were no Wednesdays available, or Thursdays.
What about July 3rd?
I didn't check July 3rd.
Because that's our normal meeting day.
Right, that's a normal meeting day.
But isn't that a holiday?
Yeah.
No.
No, it's not a holiday. I don't think.
July 4th is a holiday.
This room?
And here's the, I know a lot of people,
I think this was Member Highland's motion, but go ahead.
I'm sorry, I know a lot of people would like to have July 3rd off because of the July 4th holiday, but, City Hall will be open July 3rd. City Hall will be open July 5th. July 4th is a one-day holiday. It's not like Thanksgiving or Christmas or where you're going to be taking half a week or a whole week
It's like
off.
Passover, it's 8 days.
Yeah, there you go. Or Hanukkah is
Yeah,
8. July 4th is a one-day holiday, and I really, my inclination would be to hold our meeting the first Wednesday as we normally do.
My concern is
I
quorum.
second that.
Oh, well, can I get an informal straw poll of the board? Because I'm not going anywhere, I'll be here, but my concern is quorum. I don't want to walk in here and find out we only have 5 people. So let's start. Yes?
If the meeting is scheduled July 3rd, I will be here.
I got 3, 4,
So will I.
5, 6. We have quorum.
July 3rd?
July 3rd.
My in-laws are in town, so I'm fine with being here.
8. So we're 8 right now. Is everyone saying yes?
Yeah, so
More like maybe.
You're maybe.
so we're only missing Chair
So we're
Grant.
7. And
Which
8.
obviously I could cover for her again, and then send poor Miss Osbury off on a 5150. Yeah.
By Andrea, July 3rd?
Oh, wait a minute. Miss Osbury,
Uh-oh.
your vote is equal to all of ours, so share with us, please.
You may have someone else.
Oh. Can I have someone else? No, I'm just kidding.
Someone better.
I don't want to.
No, someone different, not someone better.
Let's
Well, okay,
seriously, let's
seriously.
discuss this.
Let's also think about whether complainants and respondents
Yeah, I
are as
know.
likely to show up. We may be here, and there may be no one else here, so...
So I hate to be pedantic here, but I've been asking this question for 2 months.
I know.
I have been. And you know what? I've already booked my tickets and my flight and my travel, and I'm not changing it. However, July 3rd would work. But when we talk about stuff like this in the future, let's have this conversation when it's brought up, not
I
wait for all the
agree.
rigmarole
No,
and the
I
red tape.
completely agree.
This has been very, very
No, I
frustrating.
take accountability for this as your all-the-time vice chair. We should have solved this, so I apologize for that.
Next holiday that comes up, Labor Day, or the next, Christmas, we should just, nothing else, say service to the public.
What are we doing? Are we meeting on the 9th or on the 3rd?
Can we decide?
Yeah, no, we can decide right now.
Okay, so can I suggest if we took a straw poll on the 3rd, why don't we take a straw poll on the 9th? Are we all good for the 9th at 5:30? All right, yes?
As far as I know, yes.
Bruce, yeah?
Although, again, that...
I'm not.
There are a lot of we might bump into some objections there from members of the public because that's a Tuesday and a lot of people don't. One of the reasons we changed to Wednesday was to avoid conflict with the Board of Supervisors.
Well, how about this? We stick with the 3rd.
There's no good answer here.
Well, the July
So let's
3rd is
go
the
on.
one that the public's expecting us to be at. So there is some weight to that argument.
And the person we're hurting the most here is Miss Osbury. Look at her smile, and she's like, woohoo, I'm out of here.
She's like, awesome, I'm off that month because someone else will cover.
Just out of curiosity, since it's never happened, we've had somebody sit in for DCA 3. There's somebody as smart as you that comes? And he or she is versed and charismatic as you are, and... So you're not the only, okay. So what I'm getting at is, I also am concerned for the public, but if there are people that their case is called, they can say, no, I need a continuance, I'm not going to be here, correct?
Sorry. Just to give you some information, usually what the protocol is that when an agenda is drafted or when it's finalized, information goes out to those who are on the agenda. So you're talking about the complainants and the respondents.
Mm-hmm.
So they have time to respond whether or not they will be able to attend.
Okay.
So I know that's one of your concerns that came up.
So I totally lost the flick on this. So you throw up 5, and if 2 people say, I can't make it, can you put 2 others in backup position? Or
Not
no?
once it's finalized. The agenda is finalized.
So it gets fine. There was no in between. There's no, hey, can you 5 make it? Oh, so that's why we can't. No.
Right now on the calendar, it shows July 3rd as our meeting date on the public calendar. We'd have to change that, and we're going to get grief for that. That's a given. So I'd say we go with that and then work out the internal administrative shuffling to cover Ms. Osbury.
So here's my final offer, is we go with the 3rd. We'll miss Ms. Osbury terribly, but we'll have somebody else in her stead. Then we put out the agenda with however many, 4 or 5. If 2 or 3 people have a continuance, then we might have to have a special meeting, again, like we did back in January and February. That's not a motion, that's just discussion.
Wait, that means you would still have the July 3rd meeting, and then you'd have
Another meeting at some point in the future. I'm just trying to get through our backlog, David. I don't.
You mean another July meeting?
Or 2 August meetings when things are quiet.
Let's see how it goes. Let's just have the July 3rd.
That's a different discussion. I think.
This may be totally moot. We may get 5, we may put 5 people on the agenda and all 5 show up.
I said let's just go with July 3rd. I will probably not be here. But that's fine. You guys can do a meeting without me.
I'll invite my in-laws. Entertaining.
I vote to welcome.
All right, so is that decided?
Does that give you enough notice to get coverage for yourself?
Oh,
There is no notice. It's on the calendar.
It's on the calendar.
Yeah.
Okay.
So we're clear, we're not having the meeting on July 9th. We're still going to have the regular July 3rd meeting at 4 o'clock, and we're going to try to load it up with...
We have the room for that, right?
Yes.
This is our
Nothing's going to be happening that afternoon. And we will try to load that up with, 5 cases, maybe 6, so that we can get through stuff. And that they're real and hopefully not last-minute continuance. I mean, we can't control that, but at least...
Yeah, you got to remember, sometimes we get a case that takes 3 hours, sometimes we get a case that takes 3 minutes.
Understood. We're looking forward to those 3-minute cases. I haven't seen that.
No one is going to be here July 3rd. Like, the city workers are going to be gone. I mean, we're going to be sitting here in an empty room with 6 cases that people are going to say it's going to be continued. I'm not saying that it's the wrong thing for us to do because it is on our calendar, but let's be realistic.
Is the police commission meeting that
the
day?
Thursday, the night, the evening before July 4th, people are not going to be here.
That is a valid point. I think that we may be here without...
I kind of disagree because July 4th is a Thursday. People are going to take Thursday and Friday off. They might slip out a little bit early, but we start at 4 o'clock.
Yeah, but people take off early and they go and do stuff, or they go and travel.
We won't know until we do it.
No, it's fine.
And if we give...
We're probably better off if we're going to meet on the 3rd, we're probably better off trying to start early and, do a meeting at 1 or 2 when there are still some people alive in the world. But if that's not an option, well, I don't know. Whatever. I'm persuaded that a meeting on July 3rd is not going to yield real people, so it's an exercise in ridiculousness.
But one of 3 things is going to happen. We'll put 5, and 0, we'll get 5 people going, heck no, I want a continuance, or we'll get all 5 will show up, or we'll get 1 through 5, 1 through 4.
Complainants may show up, but the respondents will be like...
Is it like a half day for the city? No, there's no official half day.
It's not a half day like in school, is it, Ms. Osbury?
No, I'm sorry. Most employees they do leave early.
But officially, it's not.
Officially, it's a full work day.
So who else meets on, Police Commission?
But the defendants are all
Probation.
here on their own time anyway, so it's irrelevant what their workday is
Yeah.
in terms of the city.
You mean the respondents?
Respondents, whatever they are. Defendants.
They're not going to want to stay late,
Presume.
though, on a...
Well, if it's not important to them, they don't show up, then we find them in contempt.
All right. I don't know. I think you may want to discuss this further with Chair Grant and
I think we need a decision.
reevaluate.
No, I think Member Highland has brought up a point that we erred
Then
by
that's
putting
it.
this off, so. And if
So we'll
Chair
try for July
Grant can't
3rd.
be here, then I will be your chair. I will be here.
Right away.
All right.
So
we'll try for July 3rd.
July 3rd at 4 o'clock, is that what we're hearing?
Yep.
All right.
And I'm sure Chair
can we call the next item?
That's it. We adjourned.
Adjourn.
Do we have a motion to adjourn?
Without
I need
objection.
Do I need a motion first? Hold it.
So move.
A second?
Second. Third.
Smash your gavel.
Member Sims, second. Oh, yeah. Adjourned. I know.
Everyone have a good month.
Are we off? Oh.
Thank you.
Have a good 2 months.
Touche.
Todd, I'll let you know when we end up doing the thing.
Sure. Well done. I wasn't even